Okay, I'm conscious that time's marching on, and your time is very valuable. So I'll make a start, and we'll see how we go in terms of others coming through. So we are recording the thing, and so hopefully that will be available. So we left yesterday having gone through in terms of timescales and identified some of the key elements in terms of timescales. What I want to do now is just sort of take you through in terms of what the process is. So one of the key things is in terms of using standard solicitation documents. So that would be effectively a statement of bona fide nature of your submission, which is that you fulfill all the obligations of the supplier within the Act. So you paid your taxes, you've not been involved in fraudulent collusive practices, you've not been convicted of any of those things. And so it's a general statement signed off by you, which effectively, should that prove to be incorrect, would effectively nullify your bid submission. So it's basically a statement from you saying, yes, I am recognised and approved and meet all your criteria in terms of supplier, as a general statement would come through. You then have instructions to tender, so what you need to do, what format it needs to be, what documents it needs to include, what sort of details there would be in terms of how it would be evaluated, what the criteria would be, what the format of the documents need to be in, how many copies. So all the sort of administrative things that actually need to be in there for you to be clear in order to be able to make a successful bid. Then in terms of the tender submission process, so effectively remember, prior to the closing date, you can withdraw, amend, adjust, or whatever your submission in any way, shape or form. However, once the closing date's occurred, then effectively no changes can be made. And your ability to withdraw at that point ceases, because effectively once the document's in and it's been opened, then the validity period will start. So we've said in terms of tender validity, and we'll try and ensure that the validity period is realistic and reasonable given the conditions that apply. If there are extraordinary conditions, then it may well be that the validity requirements are adjusted to reflect those. So with minor areas of flexibility for things such as fuel, etc., where there is no control and it's a highly dynamic situation as it is at the moment. But those would tend to be exceptions rather than the rule, and ideally we would look for full coverage in terms of the validity for a sensible period. In terms of tender securities, then again, the value of those tender securities should be no greater than the cost of the documentation, and in terms of setting up a new procurement in the event of someone withdrawing. Language of the tenders, one, should be clear, so avoiding jargon, etc., but it will be a common language that will be applied, and it will be the basis upon which it will be. So if it's English, then that will be the basis in terms of how it will be delivered. Equally, in terms of currency, is it Eastern Caribbean dollars? Is it US dollars? Is it some other currency? In which case that will be clearly identified, and any exchange rates which may be applied will be clearly identified. So the date at which the currency numbers were actually set. The process in terms of clarifications, so what needs to happen, what format it needs to be in, what timescales we need to apply, and I will come to in terms of bid clarification later on, but there will need to be provided within the legislation the scope for you to request a clarification, and for there to be sufficient time for you to, one, receive the clarification, and two, analyse, assess the implications of that clarification before the closing time in any bid process. And if it is close, then the bid return date would be extended to allow sufficient time to be able to deal with those. And any request for clarification will be circulated to all bidders on the same basis. So again, fair treatment across everybody. Where there is any modifications, then Again, those should be identified and again allowed time for that modification if it comes from the procuring entity to be able to do that. If the supplier makes a modification to the documentation, then again, if it's a significant modification, the potential is that it could be deemed to be a non-responsive bid and will be excluded. So again, as part of the request for clarification before modifications are made from the supplier side, is make sure that that would not invalidate or potentially invalidate any submissions. In terms of the public tender opening, so when tender closing date is, it will be identified, and again, access for everyone into that, so that people can see what's happening, and it will be who tenders are being received from and what the value. If it's lowest tender, then it makes sense. If it's not lowest tender, I'm not sure what the value of that would actually be, but that's the process that will be there. In terms of cancellation of tenders, as I say, you're able to do any of that up to the point at which the bid closing date has occurred. If after that stage, then there is the risk of losing your bid tender security. Equally, if the procuring entity decides that for whatever reason it's not going to go ahead with the tendering process and effectively cancels the procurement, that will be notification. There's an obligation to notify all potential bidders or bid submissions that the exercise has been cancelled, and to provide indication as to what's going to happen, whether it will be reinvited later on or whether it will be excused. And then again, in terms of clarification of tenders, whatever clarification is required would be notified to all parties as part of that process. So that's really making sure is if we identify an arithmetic error, to confirm that it was an error and that you accept the adjustment. Bearing in mind, if we find an error and it's not accepted, it could potentially invalidate your responsiveness as a bid. So what sort of safeguards do we have in place? Any communication should be in writing. So whatever discussions are actually held, then it would be formalized as a written response or either in writing hard copy or electronic form. And kept as part of the record. In terms of confidentiality, as we talked about, there is confidentiality in terms of the process. So whatever submission information you offer, it would be confidential and would not be disclosed as part of that to anyone else. And where information is deemed classified, needs to be identified, then again, that would apply. And the principles in terms of confidentiality is there's likely to be guidance which says what will be deemed to be confidential, to whom it will be deemed to be confidential, and for how long that confidentiality requirements will take effect for. So the three components will make that through, and that will be identified either as part of the general introduction in terms of tendering or as a formal process and guidance note. Record keeping, full control in terms of records of all procurements that take place, both ones that complete and ones that are cancelled. So again, we have full details of all the evaluation process to ensure that whatever criteria are set, that's the base upon which it's actually done. And again, as part of the review process, either through the appeals board or through the procuring entity, again, that will be the basis upon which any debriefing would be used. As we said, provisions in terms of conflict of interest, in terms of what would be deemed to be conflict of interest, and indeed codes of conduct in terms of behaviour would be applied. And usually in some locations where I've worked, they've created what they deem to be an integrity pack, which again is signed off by the supply community, which says that yes, we will behave in accordance with the code of conduct that's actually there and will fulfill our obligations as a sort of formal statement, breach of which would effectively render them ineligible for subsequent procurements. Transparency. So again, part of the requirement within the Act is for annual procurement plans to be identified and for notices to be circulated of those procurement plans, so the supply community can see what requirements are likely to be coming through within the next year. And as we said before, if it's a multi-year arrangement, then the value of that multi-year arrangement, the whole arrangement, not just the expenditure in that year, would be part and parcel of the notice. And then for individual requirements, publication of opportunities, either through the government website or through press. Notice to tenderers of intention to award. So again, remember we talked yesterday in terms of the timescales, is the notification to unsuccessful bidders prior to the formal notification of the award notice. And so the standstill period, so 10 days for suppliers who feel maybe the decision is not in accord with what they expect and have the chance to challenge that. They have that 10-day period in which to do that, after which that option lapses. And then formally, there will be a formal contract award notice indicating the base on which the procurement has been awarded and whatever ongoing post-award activities and requirements will be in place. Equally, where there's a contract cancellation, there will be a contract cancellation notice that will be issued. So that tidies up from where we were yesterday. So in terms of the main concerns that actually should have come through as part of that, one of the things is in terms of being able to be sure when procurements come out that it is a real need. So the first requirement within the public procuring entity is to confirm that the need is real. And so as part of that is that it's then budget funding available. So once we've got a budget, we know that the need is real and that's confirmed, then the next step is to actually have the right style of specification. And principally two types of specification. There's a conformance specification and a performance specification. And I'll come to how that actually works. But effectively, what we're looking to do is to migrate away from the conformance style specification more towards the performance style specification, because that is much more beneficial in terms of being able to deliver value for money. So think in terms of what the technical and logistical considerations are. So is it compatible? So what are the compatibility issues? Because again, we have the option in terms of proprietary items, but where there are alternatives, it may well be that you use Microsoft or whatever the system may be, but it would be then or equivalent. And so you would need to incorporate that as an equivalent. And so again, if you as a supplier see that, look at the specification and say, this is really wanting a particular system, particular process, a particular supplier's requirement, then again, it's an opportunity to be able to challenge that approach in order that it's deemed to be a non-discriminatory requirement. So you look at compatibility, things like ground conditions. So again, any surveys that are done, that information would be incorporated into the requirement. Things like location and seasonal weather conditions, etc. So looking at both a technical perspective and a logistical perspective. So when it would be available, how it would be available, or the particular constraints in terms of timing, etc. Those would form part and parcel of the risk assessment that the procuring entity would have carried out. Then to look in terms of the standards that would apply. So again, to simplify the process and to make it less bespoke is an actual sort of hierarchy of standards. So are there international standards? Are there industry standards? Are there national standards? And it's only in the event that there are none of those standards around that you would then look at developing your own standard as a procuring entity. In terms of the expression of interest, again, make it clear enough for people to understand what it is you're looking for and what are the skill sets that you expect to see for people to provide and how that's going to be evaluated. So you would then see, right, yes, we're interested, and in order to demonstrate our interest, this is the information that we will be providing, and yes, we can do it in the right sort of format that you've asked for. Then in terms of the individual procurements is the notice to go out which says, yes, we are now actually going to go out for this requirement and let the market know. Make sure, as Peter talked yesterday, that we're using the right procedure to be applied. And then think in terms of how's the best way to get that. So are we going to look at direct delivery? So effectively, the supply community would provide the inventory management, or are we going to take that on board ourselves and internally circulate the goods and services out there? And finally, to make sure that the specification that we've got does not have any particular bias. So it's not been simply a cut and paste arrangement from this is what we did last year. It's actually saying is this is what we actually need. Because it's acknowledged that 3/4 of total cost is controllable at the design stage. And so again, making sure that we get it right, because once we've set it at that stage, is our opportunities in terms of being able to adjust and amend without additional cost is limited. And so making sure the objective that we've got for the procurement is clear. So is it that we want it done in the shortest possible time? Is it that we want it to give us maximum flexibility in terms of how it can be utilized? Or is it that we're looking at something which is a statement which says this is what BVI is actually looking at and is recognized as an iconic arrangement as part of that? Because each of which of those will have a different outcome from the supply community in terms of how they put their submissions together. So in terms of specification, as I said, in terms of conformance or performance, traditionally it's been conformance, and effectively that's where the client actually says this is what I need and specifies that in great detail. What that means is that they are saying to the supply community is we have all the expertise and we will tell you how to do it. Now, my approach has always been is you guys are the experts. Let's allow you to use your expertise to come up with what you believe is the best solution to deliver the requirement within the procurement. And that's not by us telling you how to do it. So the move is towards performance. So we actually say, this is what we need it to do. So we want a school which will accommodate 120 pupils, meeting this curricular requirements for additional extracurricular activities, etc., for catering services, to apply a flow through. So you identify all the things that you want it to do, and then give the supply community the flexibility to exercise their expertise to come up with the best solution. And also what it means is that conformance places the responsibility and the risk for it delivering what it's supposed to do with the buyer rather than with the supplier. And what we want to do is to actually say, guys, use your expertise, but as a consequence of that, it means that if it doesn't perform in a way in which we want it to do, and we've told you how we want to do that, then that's at your risk, which seems not unreasonable given the nature of the requirements and the service that we're looking from you for. So moving towards performance, away from that. But equally, as a sort of rule is, wherever we try to put it together, it should be objective. And so we should have objective criteria as part of that one. So as I say, you would think here is to meet this curricular requirement, that it must meet all structural standards and applications, must be capable of withstanding hurricane conditions on the basis of a 1 in 100 year event, etc. In terms of functions, so we'll be carrying out in terms of science, in terms of IT access, as well as the sort of generic issues. So it must have sort of non-allergenic paint surfaces, etc., and each of which must be measurable. So capable of the through flow of children within a given period of time. So in terms of catering, so capable of satisfying food needs within a 1 hour time slot, etc. All of those are then measurable, and it either performs or it doesn't. One, it makes it easier for the evaluation team to be able to assess. And two, it actually then creates automatically a set of performance criteria that can be used post-award of the contract. And so that means that we have to say is any particular technical issues that we have, any qualitative issues that we have, and any performance characteristics that we have need to be made known as part and parcel of the bid document. Right? And equally, as part of assessing that is to make sure that what we include in there is not likely to minimize the competition or exclude people from that because we're asking for something which is particularly specific to a given supplier or a given system or process. So we can't come up with things which would minimize competition. So the specification should always be designed to give us that maximum output in terms of competition. Where we've got as part of the description, which is why performance makes sense, is, however, if we get to a point where there is no other way of describing what that need is other than using a brand name. So if you've got an SAP system, then clearly you say it's an SAP system. And so anything that has to work has to be compatible with that system. Or if there is an alternative, then we would include within that or equivalent. And what that means is that you can come up with an alternative as long as it meets in terms of compatibility, in terms of performance requirements, we can't exclude that alternative from the evaluation. And equally, as we've talked about sustainability, then things like energy consumption, things like recyclability, things like emissions would also be incorporated within that in terms of standards that will be applied. So once there is an environmental sustainability policy in there, then that would be shared and it would be incorporated into all subsequent bid exercises. However, it would require sufficient notice for you to gear up. So we couldn't say, right, with effect from tomorrow, this is what's going to happen. So there would need to be a sensible notice period or lead time for the supply community to be able to gear themselves up in order to satisfy that particular change in requirement or obligation. So any questions on specifications? Okay. Peter, do you want to pick up on solicitations as a solicitor? Oh no, you're a barrister, aren't you?
I'm a barrister. I don't solicit. That's it. So yeah, I would like to, so solicitation meaning advertising. So we're back onto the issue of transparency, which of course is one of the key principles that we've been discussing. And for suppliers, for you, obviously, it's very important that you know when there's going to be a contract up for grabs. So you need to see the advertisement, and that's really what this is all about. So when the procuring entity will be using open tendering, they have to make a public announcement. So this will be an announcement just setting out the name of the project, roughly the size of the project, the location. It will have as much information as you can fit into a little advertisement that fits in the newspaper, for example, and they have to publish it in a newspaper of wide circulation in the Virgin Islands. They also have to publish it on the public procurement website, and that's the website that is or will be maintained, I'm not quite sure, but will be maintained in any event by the Ministry of Finance. And if they're going to be doing international procurement. If they're going to advertise it internationally, then clearly they have to advertise it internationally as well. So they will have to find an appropriate international publication, if it's hard copy, or an international website. The multilateral development banks have websites for this, and there's something called DG Market, and they might be able to use that, but it will be advertised further. Remember, however, that international tendering is not an obligation, and certainly for any contract below $100,000, the government is probably going to limit access or limit the competition to national tenderers. If there is no national availability of a certain product or a service, then they will have to go internationally. But certainly below 100,000, it's very likely that it will only be bidders from the Virgin Islands that will be invited to bid. Under restricted tendering, and you remember that yesterday we discussed different reasons for using a restricted tender and therefore for not advertising. Well, here that's the point. There is no publication. You're not going to be able to follow this on the website or in any newspaper, because the invitation is sent directly to the tenderers who can supply. Remember, the first reason for using a restricted tender is that there is only a limited number of suppliers, and therefore a direct invitation will be sent to those. Where it's not a question of having a limited number of suppliers in the market, then, as I said, the second reason for using restricted tendering would be to reduce the numbers, because it would be disproportionately expensive to carry out a full tendering procedure if the products and services are fairly standard and fairly low value, not below $10,000, but if it's at the lower end of the scale. Then if a procuring entity is expecting a lot of bidders, so for standard products, things that are readily available, then it can reduce the number. And I think, as I mentioned yesterday, this is a bit of a tricky situation, because the law doesn't, and it's not just in BVI, it's any law that contains this, never really explains how you can reduce that number. I mean, how you would identify the number to invite, but that would generally be from people that are known to you, historical information setting out who is capable of and who has delivered those supplies in the past. So that's probably what they'd be looking for. But if you feel, for example, if you see that one of these contracts has been awarded by a restricted tendering method, and you think that it's always the same people, or it looks like it's rotation or something, then you are entitled to make a challenge and to challenge the reasons on which that the procuring entity has used this restricted tendering method. The conditions that do exist. Oh, you're muted. Rob, you're muted.
Sorry, Pete, I was just going to say, if I was a supplier who wasn't on the restricted tendering list, how would I know that the solicitation has been issued in order that I could make a challenge? Is there anything that's identified within me that would help me?
Was that a question, or is that a rhetorical question?
It's a question. I was just saying, is there anything? So if I was a supplier, and the procuring entity was using the restricted tendering process, therefore I wouldn't necessarily know about the solicitation until it's been done. Is there any way that I could get advance notice to say, hold on a minute, I want to stop this because I think I should be included in it? Is there? Okay.
Oh, sorry. I mean, if you're asking me, I don't think there is anything specific there. There will be a contract award notice, of course. So at the end of the day, you will find out, but that may well be too late. My suspicion is that suppliers will find out about it because other suppliers, their competitors, will be crowing about the fact that they've been invited and others haven't, so, which is not a particularly formal method of information.
No, the only thing that's what I've done in the past is where we are looking, so as part of the procurement plan, to actually see what it is we're actually likely to be going out for. And so as suppliers, what I would say to them is look at those plans, see what those are, if you believe that those are areas that you should be involved in or you want to be involved in, then approach the procuring entity and actually express your interest at that stage. And so you can actually say, I understand you'll be buying IT hardware, IT software, or whatever it may be. I wish to be considered as part of that. And can you notify me as and when any of those may be coming, so that I can be sure to be included? Or if I'm not going to be included, can you notify me that I'd be excluded, which then gives me the opportunity to be able to say, yes, I'm comfortable with the criteria used to exclude me, or I think you've not been fair, there's bias in there, and that then gives me the opportunity to challenge. So rather than having to wait until it's too late, because by the time it comes to the award notice, it's going to be pretty much too late to be able to stop it at that stage. So from my advice and guidance would be in terms of suppliers is, one, please take advantage of the annual procurement plans, which you'll see. You can see what it is and use that as a means of being able to express your interest in that and to be considered within any sort of process that goes around there, in order that you can then have advance notice and you don't have to wait until it gets the award notice, by which case I would say pretty much it's too late, because you have such a short window to be able to deal with that. And if you've not been involved in it, to try and catch up on that is very difficult.
Yeah, absolutely. I think that's very good advice. And remember, procuring entities, they may rely on the same tenderers over and over again, but that doesn't mean they're trying to do something wrong. It could be that they're just very lazy, or it worked before, so why not do it again? So if you're proactive as suppliers and you point out to them that actually you do operate in one of these markets and should be invited, they may well invite you directly in a restricted tendering procedure. Not everything the procuring entity does is for bad reasons. I mean, it's just so much easier to go to the same people because we always get the bids. For them, of course, that's bad procurement, because they should be searching for new entrants and new suppliers and hopefully getting better prices. But that's not always how the public sector works. We all know that it's an easier life just to go and do what you always do. Hopefully that's something that will change, because the Act and the regulations try to make the procuring entity more proactive, but equally you need to be proactive in order to try and search out these opportunities. So I think that was great advice. Looking at the annual plan will give you an idea of what it is they're looking for, and will quite often state the method they're going to use. So it's very easy then to identify the opportunities that might come up. So I agree, that's very good. When we're talking about requests for quotations, which comes to the very lowest value contracts, $10,000 and below, and this is the standard equipment again, and for very routine works and maintenance types contracts, then there again, the procuring entity will invite tenderers directly. There's no advertisement here, and they must invite at least 3. So they invite quotations from at least 3 tenderers, as many as they can, but at the very least 3. And a similar process. You could be very proactive about this. I don't know if, in fact, I'm sure they don't. If the government in BVI actually conducts things like vendor meets or goes around and talks to the supply community to any large extent. But certainly in those sorts of fora, you would be able to, to demonstrate your interest, and therefore, above and beyond the annual procurement plan, you may be able to make yourself known. Don't make yourself too known, because of course that just upsets people, but certainly make yourself known, so that you might get a chance to be invited in one of these areas where there isn't a public announcement. And in single source, again, that's also going to be by direct invitation. That's not going to be done through a public announcement. So that's, you need to be chosen for that. Sometimes you're the only option because you have a monopoly right, but in other cases, again, you should make yourself visible. But that's a question of marketing, and I'm not going to try to teach you how to do marketing. I'm sure you know how to do that much better than I can. Okay, so then let's go on to the tenderers themselves. You need to be qualified, of course. And the ones who are qualified under the Act and the regulations are those that have the necessary professional, technical, financial and managerial resources, as well as competence to complete the contract. Now, the Act and regulations don't go into much more detail than that, but clearly it will depend very much on what the contract is, what the nature of the works and services are, the extent of them, the complexity of them, how difficult it is to find the location, all sorts of things like that. And there may be, you know, if you're doing consulting, you may need back office support in terms of managerial support and resources. You have to demonstrate your competence. Now, what will happen is there's, as Rob explained, there are standard solicitation documents that will be prepared, and those will set out the requirements that you need to meet. So they will say, in terms of professional requirements, this is what we're looking for. In terms of your technical capacity and technical facilities, this is what we're looking for. In terms of your financial health, this is what we're looking for. I'll give you an example. I mean, this is very strange. In the European Union, they have they don't actually say what financial criteria will be applied. That's left to the procuring entities. What they said was, in order to demonstrate your financial status, you can provide bank statements and certified accounts and so forth. But sadly, a lot of procuring entities in the European Union, at least, didn't really understand what the purpose of all of this was. So would routinely ask all bidders to provide their bank statements, copies of their audited accounts and so forth. And when you ask the procuring entities for what purpose, well, it's just we're allowed to ask for them, so we do. As if that's going to demonstrate whether they're capable financially of carrying out the contract. There are methods of working out, you know, you look to see what the turnover is, what the outstanding liabilities are, do they have access to credit facility and so forth. So will they be in a position financially to carry out this contract? And are they doing other contracts of the same value which would undermine that ability? So there are reasons, there are things that you would be looking at to make sure that you know, the procuring entity would be making sure that they knew what financial status or financial health level they're looking for. But my experience is, at least in Europe, that people really don't know that. They might just ask for the details, you know, the proof that they require without knowing what they're looking for. I don't know what Rob's experience is on that, but
yeah, I mean, exactly right. In terms of the financial stuff, is of course in Europe and indeed worldwide, there are organisations that will do account analysis. So they will do the ratio analysis and will say, based on the information that is presented in the accounts, and bear in mind the accounts may not necessarily be up to date. So I would always say your latest account is then this company is eligible for contracts up to a value of whatever. And there's a basis in terms of financial, that's what I would apply. Equally, I don't want to see your parent company financial details. I want to see your financial company details. And so when it says all of these is, you may well have a huge organization that sits behind you, but if they're not going to be involved in carrying out the procurement, it's of no value to me. And so again, be very clear, what the procuring entity will be asking for is about you as the contractor who will be carrying out the work, not you as an organization who may have a global presence in terms of all sorts of things. I'm interested in who's going to be doing it within BVI, not in Asia, China, or wherever it may be. And so, yes, in terms of financials, it's relatively straightforward to do ratio analysis. And again, this is one of the things that I would see is, instead of asking for company accounts for every single procurement, do it once on an annualized basis and say, based on the information provided, this company is eligible for contracts up to the value of whatever. That simplifies the process, makes it much easier, makes the whole evaluation process and the cost of putting those things together equally well. Because I know, having sat from both sides as a supplier and as a buyer, is the last thing I do, and it irritates me intensely having to send my accounts through on every single procurement that I actually do. And you say, well, you only had one last month and my details are exactly the same because my financial year is still exactly the same. So you will get exactly the same information. Why do you need it twice?
Yeah, no, that would be good. Now we're depending on the procuring entities to take that very practical approach.
Yeah.
But often they don't.
But that's certainly what we as part of this in terms of best practice procurement principles is recommendations that we're actually making to be able to do that. And it also makes them more attractive as a potential customer than instead of saying this is just hugely costly from an administrative perspective, which has no value.
Absolutely. So the standard solicitation documents give space for the procuring entity to set out all of those professional and technical criteria that they will apply. And that's where you will find out what documentary evidence they need. And let's hope they'll only ask for what they haven't received already in the last 12 months. But that's still an open question. But that's what you will need to demonstrate. You will have to show them that you are qualified in those circumstances. Now, no criterion can be applied that is not in the Act. So if it's anything other than professional, technical, financial, managerial, or competence, they're not going to be able to apply it. The Act limits what they can test for. And if it hasn't been disclosed in the pre-qualification documents, if there is pre-qualification, or in the solicitation documents where there's no pre-qualification, if the criteria they apply is not disclosed, they will not be able to apply it in the evaluation at the evaluation stage. So this again is an issue of transparency. It's a way of controlling what the procuring entity can ask for. They have a whole range of things they can ask for, but they must do it, and they must do it in writing, and you must see it. They can't then change their mind. They can't say, oh, actually, my friend has got another criterion that might be quite useful. Why don't we add that in and let's evaluate that? No, they can't. If they haven't said it up front, they're not going to be able to apply it.
And also it stops the procuring entity saying, oh, well, it looks like the company that I would prefer to win the business is not going to get it. Therefore, let's just adjust some of the things that we're actually going to look at in order that we can change it. And so the purpose of actually setting it out and fixing it in advance stops that opportunity arising, because you can't do that. And if it's identified that they've actually done that, then effectively that's grounds for challenge against that procurement.
Yeah, absolutely. And none of the provisions that they apply is permitted to discriminate, of course, against or among specific tenderers or categories of tenderers. And they have to be objectively justifiable. So all of these things are very important for you to know. And if any of these requirements are breached, then you're perfectly entitled then to bring a challenge.
Oh, I appear to have.
Sorry, back again. I don't know what happened. Can you just give me 1 second? I'm really sorry, but there's a slight emergency I need to deal with. I will be back.
Fine. Well, in terms of, I'll sort of pick up from there. So,
but yeah.
Again, in terms of eligibility, then again, it sets out very clearly what are those things that will be deemed to be required in order for a supplier to be deemed to be eligible. So again, not being solvent, not in receivership, bankrupt or whatever. And this goes back to the obligations that we actually should have said. And so this would be what would fit as what I would term the sort of bona fide nature of the bid. So you would sign off to say, yes, all of these things, I can assure you that none of them apply to me. Therefore, I am eligible for any of the requirements that actually come through as part of that. So in terms of disqualification, so one of the things that we would need to sort of look at is if we believe that the procuring entity is uncomfortable with some of the activities that's gone through. So if we suspect corruption or fraud or collusion, then what we can do is we have the ability to be able to exclude those tenderers from that. Now, clearly, as part of that, in order to be able to do that, there needs to be a set of rules in terms of what disqualification means and how long that disqualification may apply for. And again, that's something which is currently being sort of worked on to come up with that. But there will be a sort of formal process which says in the event of evidence coming to light of any of the obligations that we said in terms of eligibility, particularly where suppliers have signed a statement which says that none of those things apply to me, and it's subsequently find they do, then effectively, one, that would be grounds to terminate the agreement that they may have been successful in, and two, to exclude them from bidding for future arrangements for a defined period of time or until evidence is provided which indicates that the grounds upon which the disqualification may have been applied would no longer be applicable, and they can provide evidence in terms of that one. So the individuals who may have been involved in fraud are no longer working, or etc. So you can come back and seek a review of any disqualification status, but it has to be based upon the submission of additional information, new evidence to indicate that the position is different. So I don't know whether you want to add anything more on that, Peter, or
the only thing I was going to say was that the Act does say that there is a disqualification in the event of debarment. I know that's what Rob was talking about. So it does say debarment. The issue at the moment is that there isn't a procedure for debarment, but clearly, if you can be excluded for debarment, then somehow we have to make sure that that procedure is in place. And I know that that's being considered now as part of the regulation. So I think you will find that there is a procedure related to debarment, and that really is, as Rob was saying, you know, this sets out the grounds for which you could be debarred, and debarred means prevented from bidding for a period of time, and then the procedure which is undertaken, and that would also include then probably would include different periods. So if it's a first offence, maybe there is no debarment, but you would have a warning letter to say, well, if you do it again, you're debarred. And then if it's a pretty bad one, maybe you'd be debarred for 2 years, maybe 5 years if it's a really bad case of corruption, or it's a second or third instance of doing it. And so it's very rare that you would be totally debarred, because frankly, in a country the size of the Virgin Islands, debarring people would actually reduce the market, and the last thing we want to do is reduce the available market. So I suspect any permanent debarment would be highly unusual and probably unlikely. But there's a lot in between that, and you can still lose a lot of business even if you're debarred for 2 or 3 years. So it's a serious sanction, it's a serious penalty. And so it's important that there's a procedure in place to make sure that it's fair for everybody.
Yeah, and the grounds under which it is, and the rationale that's applied in terms of classic things is like what's a minor infringement and what's a major infringement would all again need to be as practically possible defined. So again, people understand, yes, that's deemed to be a major incident or a major breach or whatever, and that requires whatever it is, 1 year, 2 years as part of that. But as I say, within that, there should be, and usually is where I've been before, is the opportunity to get a review of that decision, generally on the basis of this was a basis of my debarment. Those circumstances no longer apply, and here's the evidence to prove that it no longer applies. Therefore, can you reconsider my status? And again, the procuring entity would have the ability then to revise their decision or revoke the debarment as part of that. The other question that also needs to be addressed is if a supplier is debarred from one particular procurement, what happens to those procurements that they may currently have that are in process, and again, that's something that would need to be considered as to whether or not debarment happens immediately and happens across the board, or whether it is because it is procurement specific.
Yeah.
Okay. Anything else on disqualification?
No, I have nothing else to add. I mean, I think that covers all of the grounds for for selection. So we've talked about eligibility, we've talked about qualification, and we've talked about disqualification. So I think those are the three areas that you need to look at. But of course, we also need to look at the tender as well, the bids that are put in. And that's not just a question of looking at which one is the best. If we go to the next slide, Rob, it's not just a question of looking at which is the best. The tenders that are going to be evaluated do need to be responsive. So the first thing that the procuring entity will do is to make sure that it is responsive. And for a supplier, you will have to go through the instructions to bidder and that Rob described, and the standard solicitation documents, because they will set out what makes a responsive bid, because there's no point for a silly mistake to be excluded from the evaluation. So just be very careful when you look at the different requirements that a procuring entity will put in place, so that you can have a responsive bid. Now, a tender, a bid is responsive when it conforms to all the requirements set out in the solicitation documents. And this is all the requirements. So Rob went through things like even the number of copies, the way in which the envelope is presented, whether there is a tender security if that's required. All of those things are part of looking at what a responsive bid is. It's not just a question of looking at, the statement, the technical specifications, do you meet those? Well, of course, you need to meet those if you're going to be evaluated, because if you don't, it's a non-responsive tender. But it also means all of these other potentially silly things like the number of copies. But if those are the requirements of the tender, then you do have to respond. You do have to be compliant with those. So be aware that even if they seem to be unnecessary conditions, you still have to comply with them in order to have your tender, your bid evaluated.
But also what it can do is if it says 6 copies and you only include 5, then clearly what they can say is send me another copy, and effectively that would be there. And that's the sort of practical application in terms of that one. So it's not about being so pedantic as to say, well, we can't do that. However, I think Peter's probably going to pick it up on the next one. Sorry.
Yeah, no, exactly. I mean, you should still try to meet the conditions, but if you don't, if it's a minor deviation, and that means if it's a deviation, if it's a failure to meet a condition that really doesn't materially alter the tender, then it could easily be remedied. And Rob picked up the question, if they ask for 6 and you send 5, well, that makes no difference to the content of your tender. It's not going to make you win or lose the tender. So they can easily say, well, we wanted 6, so give us you can just say, well, photocopy it, but I wouldn't. I would just say, here's another copy if you want it. So that doesn't change the content of your bid, and I think that's what's very, very important. So
and equally, if they don't allow you that opportunity, then again, it would be deemed to be unreasonable, and you would have reasonable grounds to actually say, well, hang on a minute, am I being excluded for something which is so minor when it could be so easily resolved without impacting upon it?
Yeah, and this will depend on all the circumstances, but I think the number of copies is really a very good example. Another one would be arithmetical errors. Now, these are not necessarily minor deviations, but if it's simply an error that can be corrected, that doesn't change the substance of the bid either. It's just somebody has had a typographical error, somebody's made a miscalculation. Although it has to be said that sometimes arithmetical mistakes are put in deliberately in order to allow people then to correct them in the way that suits them. That isn't permitted. So it's simply a question of whether the numbers add up or not, and that would be a minor deviation which can be corrected. If there's a deviation there that does affect the bid in some way, for example, it could be, for example, the number of days. If there's a date for delivery, and we're talking about sort of 6 months ahead, and the bidder says, well, it's 6 months ahead plus 1 day. I just can't make that day. then you might be able to quantify that and say, you know, the cost to us of having one day's delay could be X. So if you can quantify it and it really is only a minor deviation, it doesn't really affect the content of the bid, then it could be done like that, and you can take it into account provided you can quantify it. I'm sure Rob has come across many more deviations that may or may not be acceptable.
Yeah, the thing is, and again, from a practical perspective, what should be done is to look at what would normally be used as liquidated damages. And so if you identify those things which will be subject to liquidated damages, so you can quantify that there is a cost implication of those, then clearly it's there. But if you can't quantify it into financial terms, so someone says is, well, given the sort of Gantt chart that's there, is we have a slippage time built into the Gantt chart of 2 weeks. Now, if it goes through there, we'll actually pick that up so you can reconfigure the Gantt chart in terms of timing there. Then again, that wouldn't really impact upon it because there's no cost implication in terms of there, because it'll finish the end date. And so again, the true test is there a real cost? If there is a real cost and you can quantify that, that's legitimate. If you can't quantify it, then effectively you can't just say, well, I don't think I like that, or I'm not comfortable with that. That doesn't hold water within the law, and that's what the law is designed to do, to say you can't use those, oh, I feel, my gut feel is that that's not going to work. Well, I'm sorry, gut feel, however important, however valuable you may feel it is, won't work under these circumstances because it's not objective in any way, shape or form and can't be quantifiable.
Absolutely. I mean, another silly example, or not a silly example, but another example of a deviation that's very minor could be the failure to submit a document. Of course, the argument is, well, you knew you had to submit a document and you failed to do it. Let's say it's your annual accounts. Well, if you don't submit your annual accounts, it doesn't mean that they don't exist, and it doesn't mean that your financial situation has changed at all. So accepting that, if the copy was not delivered at the beginning, doesn't change the bid at all. It just corrects a mistake. It corrects the absence of the document. So that sort of thing would also be permitted. There are much more difficult areas, but obviously the idea is, as far to the extent possible, to comply with the requirements set out in the solicitation documents.
But it's actually setting in a framework and scope that as long as it meets that requirement, then the procuring entity has no legitimate means by which it can exclude your tender for grounds which they can't sit in terms of responsiveness.
Yeah.
Next slide.
Yeah, that's over to you, I think.
Yeah, indeed. So in terms of bid clarification, remember what I said is any request for bid clarification should normally have a time limit, which is where we go back to the point of ensuring that the time for the bid to be out for people to put together their submissions has to be sufficiently long enough to allow them, one, first of all, to understand it, and two, be able to prepare what it is they need to do in order to complete the bid, and then complete the bid process itself. And so usually there would be, and again, 10 days would be what's seen as being sort of reasonable to be able to do that. So if you have a 28-day time limit for the bid document, then that gives you 18 days to sit down and work through and identify how you're actually going to put it together, what that's going to look like, in order then to actually say, well, these are things which I'm not clear about and I need clarification on to be able to do it, rather than leave it to the last minute. If there is a shortened ones, and remember where we're looking at national ones and we're looking at restricted, then maybe it's 14 days. And so it's relatively short, the timescale that you've got to be able to look at it and evaluate and identify any possible questions. But remember, restricted should be for relatively straightforward, simple items or services, and therefore the time it takes to read and understand the bid document should be relatively short. So there should still be enough within that. And so 10 days before that, that then allows the procuring entity to investigate that, come up with the information if it doesn't have it readily available. And then they've got 3 days to be able to put that information together and then circulate the response to that bid clarification request, giving at least 7 days left in the bid process timing for you to, again, assimilate what the information is and amend, adjust your original bid submission profile to reflect the new information. If it takes longer than 3 days to collect the information together, which means that there is going to be less than 7 days available, then one, confirm that that would be acceptable to all bidders in the time that's available, or where preferable is to extend the deadline to give them at least 7 days. So if it takes 10 days, 10 days to go, a bid clarification request is made, and then it takes 5 days to actually get the information together and ready for circulation and out back to the bidders, then again, part and parcel of that bid clarification would say is, in the light of this bid clarification, we are extending the deadline by 2 days in order to give all bidders 7 days to study the information and submit their revised bid document if they've already done it before, or to adjust their original bid proposals to reflect the new information. So whatever clarifications are requested by individual suppliers, that information goes out to all potential bidders. And that then becomes a formal part of the bid documentation and effectively forms part of the evaluation process. So once it's in there, then if that impacts upon any of the criteria that were set as part of the original evaluation criteria, then that change then automatically becomes incorporated into the bid document and forms the same, has the same legal status as the original bid request. And if it's necessary, so it may well be it's something particularly complicated, then can they be clear and confirm that they've understood the information that you've sent as part of bid clarification, or if it's still not clear, to confirm that it still remains unclear and for you then to provide additional information. So one bidder requests information, and it may well be that in the light of that clarification information that's gone out to all bidders, an alternative bidder says, oh, right, I'm not really sure what this means in terms of how this is going to impact upon me. Therefore, I think I need to seek clarification on that one. And again, if the procuring entity has sent it out, part of that process should be to confirm that all bidders or potential bidders are comfortable and understand the information and are still able to meet either the original closing date or the revised closing date in the light of the extension that's been given. Because if they're not, then that effectively restarts the clock again. And so what we don't want to do is to say, you've got a chance, read it through now. If you're clear, confirm you're clear. If you're not clear, then please provide us with information as to what's unclear, and we will seek to clarify that. And again, provide the same 7-day timescale that sits at the back end of the bid process that goes through. And where there are, and again, it's widely used that you'll have a sort of supplier day. So you'll have a bid clarification session where all bidders are invited to raise questions, raise issues or whatever you can then clarify in the light of the sort of comments that are made. Where that is applied, then the procuring entity will prepare minutes of the session with all decisions and clarifications that's provided. And again, that is circulating out to all potential bidders. So again, they all receive the same information as part of that. Having a single day has advantages in so much as it shortens the process because it's all done in one go. But often I've found from a practical perspective is bidders aren't necessarily as open on a full day as they would be if it was on a single one-to-one basis. So advantages and disadvantages to work with which one of those. So we've talked in terms of supplier appraisal as part of the pre-qualification process. It's really used to identify all bidders who are able to provide a compliant bid. It's a precursor to the tendering process. And again, it's designed to make sure that those bidders who are able to meet the requirements are the ones that are done. So it doesn't waste time and effort either for the procuring entity to evaluate bids which clearly won't be compliant, and for suppliers to spend time and effort putting together a bid for which they will be unlikely to be able to meet the compliant requirements. So it simplifies and clarifies the process, but equally as part of that is it should be the results of that pre-qualification. If bidders are unsuccessful, then you have the ability to be debriefed as to why you're unsuccessful, what are the grounds for their failure, and to be able to rectify and remedy that if future procurements come through. So the whole precept of pre-qualification is it should make sure that whoever you invite as a procurement entity, whoever you invite bids from, you will be pretty confident that it will be a compliant bid because you've already identified those potential areas where non-compliance issues might arise. You tend to use it for the sort of larger, more complex procurements because the timescale it takes and the cost implications and the risk implication for the big complex procurements of having a bid submitted that needs to be evaluated, particularly under open, then it takes time and effort and the risk is generally seen as being too great to actually follow it through. All applications for pre-qualification is through recognised channels, so media either through the website or through the press or through radio or whatever the means might be. Then again, a request would be made. If you are interested in this, please indicate your expression of interest and we'll then consider it. And the key principle this is it's not about comparing performance between different bidders. It's about a yes, no decision. Are you capable of providing a compliant bid? Yes or no. It's not, are you any better than someone else or are they better than you? Because that's really is not the purpose of pre-qualification. Pre-qualification is merely to set the hurdle height over which people have to get. If they get over that hurdle height, then again, it's deemed that they are eligible and capable of meeting your requirements as the procurement entity. So pre-qualifiers can look at things like business risk. So what would be the risk of dealing with you? So from a technical perspective, do you have the necessary capacity? Do you have the necessary qualifications in terms of people? Is your workforce the right sort of thing? Have you operated in similar locations on similar kinds of projects? So from a commercial perspective, do you have the necessary process to be able to manage buying in goods, maintaining the sort of supply chain, etc.? From a financial perspective, are you financially stable? So how highly geared are you? What's your net profit? What's your liquidity status? Would be things that you would look at. From an environmental perspective, so are you ISO 14000 accredited? And again, remember, it's Not necessary that you have to be ISO 14000 accredited, but do you have equivalent environmental standards which could be considered? And so you may well say, well, I'm not ISO 14000 accredited, but I believe we have good environmental standards that we apply. If that is the case, then again, the procuring entity is obliged to consider and evaluate your environmental standards and determine whether or not they meet the requirements that you would expect. So ISO 14000 is just simply one means to simplify the process, but it doesn't mean that if you're not ISO accredited, that you're excluded. And the obligation on the procuring entity is to determine, is that compliant or is that not compliant? And then in terms of people, so do you have enough people? Do they have the rights to the skills? Are they in the rights of location, etc.? So those are things that you would look from a business risk perspective, pre-qualifiers. But equally, in terms of appraisal, is you would have two stages. What do people need to do in order to get a bid? And then what do we need to look at when we've received those bids in terms of the supplier's performance? And so there, post-evaluation is you would look at time. So how often do you deliver your projects, your contracts, your goods, your services, etc. on time? Do they have all the quality standards that you would expect? So are they complete? Are there errors and mistakes, etc.? Is the materials that they use with suitable sign-offs in terms of lifespan, etc.? In terms of the service, so do you have ongoing maintenance? Do you have mean time between failure analysis, etc.? And then in terms of cost control, so how do you ensure, do you have contracts in place for the goods and services that are likely to be required as part of this procurement? So how well do you control your costs? And again, those would be things that you'd look pre and post as the two parts that fit together. So again, we said two forms in terms of evaluation, lowest price. And again, it's very rare where there is only price as a determinant. And it's where everything else in a particular market are exactly the same. So the classic would be, although even that is slightly different, it would be fuel. So if it's diesel, it will have a standard. If it meets the standard, then the only differentiator that there is the price. And so you would be quite legitimate using purely and simply lowest price in terms of that. But you could also then say, well, yeah, that's fair enough. But what if the lowest price is in a particular part of an island, which is very remote, and therefore my costs to actually go to that location to get fuel from that point actually cost me more than if I just simply go down and to one which is much more convenient. So even on those areas where the product itself is pretty much consistent across, there are other factors that you would do. And so I would generally say is look at most advantageous tender as the option to consider, because that way it allows you to take into account all those factors which will be important to you in terms of making that decision. And it's also important to suppliers who say, well, I will never be the lowest price. And it also stops people from saying, right, I'll build it to the lowest price and I'll look at finding the cheapest materials I can possibly do in order to, because you're actually saying, well, hang on a minute, if this asset has a life, it's not just simply the build cost. So it's not just the capital cost, it's the revenue costs. And we need to include the revenue cost as part of that because it's the overall cost for that asset. And so the strong recommendation is to use most advantageous tender. And it may well be that at the end you say, well, yeah, most advantageous tender is 90% price, but also there is still a small element of things which are actually in there. But whatever that may be has to be made clear to all bidders. So in the bid document, saying we're using most advantageous tender, and the criteria are as followed. And they would normally be listed in descending order of importance. So the most important, whatever appears first is the most important one. And it may be that you actually say this is so important and it's so clear is I'm actually going to say is what the percentage profile will be in terms of the weighting for these individual components. So again, you as the supplier can be very clear how to submit your bid to reflect that requirement to demonstrate compliance against the criteria that's been identified. So very clear that if we miss in the solicitation document and we say, sorry, yes, there was something else that we really should have considered, tough. If they try to use something different to that, then effectively that negates the procurement and they need to start again, because he's saying well, hang on a minute, it's not the same as it was, therefore we need to do something different. And if we need to do something different, then that effectively stops the procurement. And also, in terms of how you're going to evaluate it, this is what we're going to do. So are we going to put it under test conditions? So if we're looking at water flows, how are we actually going to do that? So we're looking at pumping under emergency conditions, etc. How are we actually going to do it? So again, has to be clear what it is you're going to look at, what criteria you're going to look at, and how you're actually going to look at those conditions. So is it going to be by desk research? Is it going to be by practical analysis? Are you going to look at certified performance criteria? How it's going to be. So again, the supplier can be clear what they have to do in order to make sure that they submit it in a format that makes sense and means that they will be responsive. But if you're using non-price evaluation criteria, again, key criteria, it has to be objective. So if you're looking at sort of technical issues, then you could say how many projects have they carried out in the last 5 years? The more projects that they carried out which are similar in the last 5 years, the more marks they would get. In terms of, are they within the Caribbean, within BVI or whatever, then again, you can set the criteria in terms of that, but it has to be objective. So if I'm a supplier who hasn't supplied to BVI in the past, and it says, projects supplied or carried out within BVI, then I could say, hold on a minute, that's bias, that's unfair. Excuse me, if I can show you that I've worked in Grenada, in St. Lucia, or wherever it may be, and on a similar project, then that would be suitable as a way to be able to demonstrate in an objective way. So, okay, it's not in BVI, but it's within the geographic region and it's for similar projects. The more they have, the higher the score they get. And where we can, express that in monetary terms. So if on a road construction, the project is scheduled to be done in 20 weeks, and someone says right, okay, I can do it in 16 weeks. It's going to cost more, but what you can then as a procuring entity say is, well, what's the cost of disruption for 4 weeks? I can work out how much traffic will be on that road, how many people will be in the vehicles that are on that road, how many hours lost would there be as a result of that disruption. And that can then be used to say, right, so it may cost me $1 million extra, but in disruption, in terms of time, cost, and productivity, it's $1.5 million. Therefore, it's more cost effective to take it in a shorter term. So again, you could use factors like that, which would be a non-price evaluation. So actually saying is in terms of time, but I can then express that time in monetary terms, which can then be used to come up with the final outturn cost as part of the evaluation process. So it has to be quantifiable. So again, you can say well, here's statistics that we can use on this, that we know what the traffic flow is and how it's actually going to work, how many people are done, we know what the average salary is. So you can come up with that calculation to identify that. Clearly, the more complex those calculations are, usually the more valuable the contract will be. because you wouldn't want to be doing so if you were simply putting in a sort of minor traffic adjustment, so replacing traffic lights with some other form, is then you wouldn't necessarily say, the cost of that to do the full detailed analysis in terms of what the cost benefit would be of actually saving a week would be relatively small. And so again, it's about being practical and applying those in a sensible way. And in terms of you can't come up with a quantifiable element of it, then what you would say is we realize that time is the most important one. And so time will be first, maintenance will be second, scope could be third. And so you would list them down in descending order of importance and put relative weightings on it. So it may well be that you say, from a technical perspective, all the criteria that we'd look at is we would whatever score they get, we would multiply by a factor of 3. From a financial perspective, so we're looking at the financial accounts and in terms of their ability and their capacity to maintain cash flows, etc., we would see that not quite as critical as technical, but still important. So we'll weight that by a factor of 2. In terms of the vehicles that they have available that are needed to be able to do that, or the people that they have available, yes, that's important, but we'll only weight their score by 1. So you can use weighting as a means of being able to reflect the importance of the individual criteria where you can't necessarily reflect it in financial terms. And whichever way you're actually doing and the methodology that you're going to apply will need to be included in the solicitation document. So you as suppliers will be clear what is going to be done, how it's going to be done, and therefore should reflect that requirement in your bid submission. Does that make sense to people? Does anyone have any questions? Okay. So in terms of specific issues, is within the Act, there is the ability to allow a margin of preference for goods produced in BVI or for labour provided by BVI nationals. So if it's an international bid, then again, you can indicate what you'd like to do is that either goods which are produced within BVI or labour which is available within BVI, a proportion of that would be expected within the bid submission that's there. And again, where you do have that kind of scheme in place, needs to be identified so that people understand what the margin of preference is likely to be applied as part of that. So again, it can be seen how that can actually work, because there's lots of ways, particularly in terms of labour. Now, you may well say is the margin is we want either a financial sum, so a percentage of the labour costs within this should be related to BVI nationals. Or equally, you can say is that what we want is not just people at the sort of bottom end of the labour market, but we want it spread across the spectrum of labour that will be applied within that. Again, you do that, and that will be then identified within the scope of the evaluation criteria that you would actually use. And so as long as it's identified how that margin of preference is going to be applied and what the basis of which the preference will be involved, then again, that can then be used as part of the evaluation criteria and built in to that evaluation process. And indeed, in the event that it's deemed not to be that element is there, can reject the submission if it's not seen to be a sensible submission. Now, the term is usually abnormally low. Now, I've seen tender submissions from bidders which have been 30–40% lower than all the others. So one stands out dramatically as being significant over the others. And the procuring entity said, we can't accept it. It's abnormally low, therefore we reject it. And what I would say is it has to be evaluated in order to be able to determine that it is actually abnormally low. It may well be that a supplier wants to get into a marketplace. It may well be that a supplier has suddenly finished an old project and has got the workforce and everything ready, so mobilization is not an issue. So there could be a whole series of factors which the supplier who has submitted a bid which is significantly lower than anybody else is legitimate in terms of being able to do it. So it's not something that is deemed to be abnormally low. There are rationale behind it. You've evaluated it and said, in the light of what I've seen and how I've done that, and I'm comfortable that they are, given the costs within that, capable of delivering the project to the standard that we expect and that we've defined as part of the specification. Therefore, even though it is significantly lower than all the others, it's not deemed to be abnormally low. And we've suitably evaluated that way. Equally, it can go the other way, and where we can look at it and as part of discussion, clarification with that bidder, we believe that it's not capable of being delivered at the time and rates that they're actually claiming to be, that we don't believe it's practically possible based on industry norms, based on analysis, etc. In which case we would then be able to exclude that bid from consideration because we believe it's abnormally low and is not capable of being delivered. But the key thing is here is the procuring entity has to carry out that evaluation. They can't just simply say, yep, it's half the price of everybody else's, therefore we're not going to consider it. And equally, if you as a supplier find yourself in a position where you are able to offer to complete a project at rates which are significantly lower than others, then if it's deemed to be abnormally low by the procuring entity, you again have the opportunity to be able to challenge that decision, to seek confirmation that your bid has been fully evaluated and the rationale in terms of why it was deemed abnormally low are objective and justifiable. If not, you again have the opportunity to be able to challenge that decision as part of the challenge process that sits within the Act. So in terms of non-price evaluation criteria, they have to link to the subject matter. And so it may well be that you say we're looking at a new harbour protection as part of that one, and the evaluation criteria would be that they have dredging facilities. And you say, well, why would that be appropriate? And so they have to be able to recognise that the evaluation criteria relate to the subject matter of the procurement. And that can be cost of operating, maintaining and repairing goods or construction. So we're looking at total cost here. We include not just the cost to set it up, so the cost to prepare the site, etc., but also for maintaining it during its life. And in terms even maybe including the disposal of the assets as part of the environmental procurement that actually sits in there. We look at time. So again, what's the cost of time, which will again take the example that I use in terms of road construction. In terms of the functional characteristics and environmental characteristics, so we can look at energy consumption. So for construction, then we're building schools, then what's the energy profile? Are they using ground source? Are they using air source? Are they using solar? What are the requirements that they're actually taking on board in order to demonstrate that they're actually going to meet lower emissions, sustainable, renewable energy sources, etc. In terms of payment, so recognizing that the longer the payment time, then the cost implications on the supplier will be there. But also, if payment is made quickly, then what are the advantages to be gained from prompt payment in terms of maintaining cash flow, etc. And in terms of guarantees, so performance guarantees, what does that look like? How is it actually built up? And how the guarantee would operate, bearing in mind over the life of the project, the exposure in terms of performance, in terms of retention bonds, etc., varies over time. And so there should be within that, if there's a different way of actually doing it, then again, how does that guarantee operate? Because there's a cost associated with holding that guarantee. Where we're looking at consultancy services, then experience, reliability, in terms of competency, and also the personnel. So the back office activity. So how does that actually work, and what is the cost implications to be able to do that? So do they deliver on time? Do they have the full resources that are available? Do they also, and this is one which is very important to the procuring entity, is that the people that we see as part of the bid document are often not the people that turn up once the contract's been awarded. And so looking at how, for a consultancy service particularly, that the experience, the profile, the competency transitions as personnel change. So you maintain the standard of what's the methodology that you would use to maintain that standard as substitutions occur, inevitably given the sort of time constraints are there. And then the sort of classic sort of caveat, any other prescribed criteria authorized or required to be taken into account by virtue of any enactment. So anything that comes through which may change that, then that may well adjust the criteria. So that may be regulations that come through, new regulations that come through, codes of practice, and so on, would be built in as part of that. And so that sits within the scope of the act and the operation so far. So in terms of pre-qualification and evaluation criteria, pre-qualification, so quality, and from here, we're looking at the quality of the personnel that are actually being used, quality of the proposals in terms of the systems that might be applied, financial standing, so are they cash flow positive, are they highly geared, resources, do they have the right number of people, or the people with the right sort of qualifications in place, in terms of track record, so have they got a record of similar projects carried out, and do they have a sufficiency in terms of numbers, the experience of people who are actually involved in there, of both practical and operational, as well as in terms of procurement activity, health and safety record, environmental record, and then in terms of staff, numbers, location, safety record, etc. So the pre-qualification criteria will be different, and you can't use the same criteria for evaluation that you did as part of the pre-qualification. Because if you pre-qualified them using that criteria, then you can't use it again as a second stage. And so in terms of quality, is you'd say is how good is the proposed solution? So are they using tried and tested principles, processes, or the resources and materials sensible that are used? So in terms of the solution, is it smart? So is it measurable, and all of the things that go with that? Then in terms of compliance to specifications, so if we're using a performance-based specification, then does it perform to all the standards that we expect? And again, it's either yes, no, that actually goes through. In terms of account management, so how available are they? Do we have special people that will actually be focused purely and simply on our project? Do we have project managers, or the area project managers, regional project managers? How is the account going to be managed? Then in terms of timescales, so what's the timescale they're looking? How are they going to measure and ensure compliance with the timescales they're actually sort of set? Are the timescales realistic? And then in terms of technical merit, do they have the right people in place to be able to deliver the proposed solution that's there? References is always one, because I've yet to find anybody who's going to give me a poor reference. So I always choose, it's like if you're going for a job, I'll always make sure that people I ask for a reference are going to think I'm the best thing since whatever. And so in terms of references, what we would normally do would be say, give me your top 10 projects. So if we're talking construction, or your top 10 customers, and let me talk to them. So I choose which references I get. I don't ask you to provide me with references. And then the health and safety environment. So what's your track record in terms of accidents, in terms of days lost, etc. Would be evaluation criteria that would look at. So pre-qualification, do they have systems in place for health and safety and environment? Evaluation criteria, what's their performance against that? And then those would be all the non-price based ones, and then added to which would then be, how much is that going to cost? And so it would then be some combination of the two as a potential percentage split between the two. And so in terms of the process of evaluation, how do we know whether we're going to accept the bid? What do we need to do in order to get to that point? So we either accept or reject the bid. So what does that mean? First thing, is the proposal in the correct format? So this is the sort of checklist that the procuring entity would follow. If it is, we can accept the bid. If it's not, we reject the bid. Has the proposal been correctly signed and authorized? So does the person have the authority to be able to respond? Yes, accept. No, reject. Are the correct number of copies supplied? Yes. No, then ask for extra copies. If they provide, you can accept the bid. If not, we reject the bid. So do we have all the key documents supplied as part of our requirement? Come on, Robert. Yes, accept the bid. No, reject the bid. Is the validity period long enough? So has there been adjustments in terms of that? Yes or no? Has a separate financial proposal been supplied? So is it 2-envelope system? Yes or no? Are there any deviations? So as when we've looked at it, if there aren't, we can accept it. If there are they material? Again, this goes back to what Peter was saying. If they are, we reject it. If they're not, we accept the bid. So you've got effectively the process that the procuring entity would be going through. And it's a straightforward process in terms of being able to do that. And so, again, you can see is what's going to be done, and you can see the basis upon which the bid's either accepted or rejected. Very straightforward. So in terms of once we're going to do it, we've got all the bids back in. So we've now got compliant bids. So does the recommended bid best meet the qualitative and quantitative criteria? And remember, these are the criteria that we incorporated within the bid document because we can't change it. If it does, we can issue the evaluation report for approval. And remember, the approval either goes to the Financial Secretary, the Central Tender Board, or the Cabinet, depending upon the value. If it doesn't, do we know why? So can we explain why it doesn't? So are the reasons that we may have in terms of that the bid, so the best bid is excluded because it's deemed to be abnormally low, or having looked at that, it's not done in terms of time. If we've explained the reasons why not, we can issue the report for approval. So again, any questions that the approval, so the Central Tenders Board, Financial Secretary, or the Cabinet are likely to have, we've got the answers in the evaluation report. If we haven't, we need to go back to the evaluation and say, why are we making this recommendation? Are the criteria used to evaluate the bids the same as those in the bid document? If they are, we can issue the evaluation report. If they're not, do we know why? Now, it may well be that in the bid document, in the light of clarification that's come through from the supplier, that we've then said, maybe we need to rethink how we're actually going to evaluate that, but we should have still, as part of the clarification notice, included that point within it. So we say is, in the original bid document, it was this. We had to make adjustments in the light of bid clarification made by the suppliers. Therefore, it's now different to what it was in the bid document, but we've explained the reason. And so that can then go in the evaluation report because it's clear, having identified it as part of the bid clarification, everybody has had the same opportunity to consider it. Therefore, we can include that in the evaluation report, and it would be something which would be appropriate to be able to accept it under that one. If we haven't, need to go back round again and say, why are we doing this? Does evaluation consider non-price issues? So are we looking at MAT rather than lowest price? If it does, then as long as we have got them in an objective format, we can issue the evaluation report to do it. If it doesn't, have we explained why we're only looking at price? If we have, we can issue the evaluation report. If we haven't, need to revisit the evaluation. So have all the non-compliant bids been rejected? If they have, we can issue the evaluation report because that then sits as part of the evaluation report. If they haven't, have we explained why a non-compliant bid is still being considered? If we have, it can go into the evaluation report. If we haven't, we need to revisit the evaluation again. Have all the arithmetic errors been corrected? If yes, confirm that within the evaluation report. If no, again, follow the reasons why. And if we can't justify it and can't explain it, then again, revisit the evaluation. Has the local impact been considered? If it's in there as part of the considerations, yes, no, away we go. So what we've got here is, again, a process to take people through. So the procuring entity will need to go through these series of checks and balances to confirm that, which means that when the evaluation report goes, it's not something which is sort of based on anything other than a formal evaluated objective process. And so the key questions that would normally be applied would be incorporated within that sort of process that actually goes through. Any questions on that? I have a chat. Right, according to the evaluation, just getting present, do you have or can you recommend, it's in types of construction, new reconstruction, a standardized evaluation matrix or templates, which include the tenders, bidders, technical, financial, and other aspects to evaluate and weight? There is a process that you would go through. And so I would take it, so you would take in terms of commercial, financial, technical, and commercial, and what's the fourth one? Technical, financial, commercial, and operational issues that would actually go, and you would set those in advance. So you'd have a checklist, which is basically the list I went through earlier on, and say those are things in there which needs to be included, because each project, particularly construction projects, tend to be different. And so you would have a tender, bidder, technical. So you'd have technical things which you would look at. So things that I would consider would be in terms of, do they have rights to the people? Do they have the rights to the qualifications? They got rights to experience? Do they have rights to the numbers? Have they done the rights to the projects in place? Do they deliver on time? So do they have a reputation which delivers on time? And so I would take that checklist and say, which are the ones that are important for me as part of that? And then the weighting, because again, weighting varies depending upon, so is this something that needs to be done quickly, in which case the weighting for all those time-based elements would be higher than if you have time to be able to take a longer lead time to be able to deliver it. And so in terms of that, the next point that I would come to would be, which is the table that I've got here, is where you've got price considerations. And so you look at it and say, here is what's the weighting. So how are we going to split this between technical and financial? And so on this one, usually you would see for sort of innovative or complex projects, you'd look at an 80-20 split between price and quality or technical. And in terms of price, again, you would say, right, lowest. So the lowest on the example that you see here, the lowest price is tender number 1 at $1 million. So that gets 100% of the weighting, which means because it's an 80-20 split, it would score 20 on the price consideration. And then all the others are then relative to that price consideration. And so the score that they get out of 20 is the weighting against their price versus the price of the lowest. And so you see is the next lowest is bidder 3. And so a 1.15. So that gets a score, which is 87% relative to the lowest price. So they get 87% of the financial score. You would then take the technical consideration, and in terms of technical considerations, things that I would look at would be, so for each score, you would get so financially in terms of affordability, then they would get yes, they got highly geared, they're not highly geared, they've got a sensible liquidity ratio. Therefore, they would get scores for each one against that standard. In terms of solution, so is a solution practical? Is it realistic? Are they using tried and tested machinery? Are they using qualified people? Do they have no health and safety issues on there? Those would then be linked to, so for each one of those, they would get a score. So the more of those, so if they have from a health and safety record that they've got less than 5 days lost on a project of 100 days, then they would get scores. If they have more than 5, more than 10, more than 15, etc., then they would get a lower score. So you set the basis upon which each of those are actually evaluated, and that then gets their technical mark. And bearing in mind that the higher the technical mark, the higher the weighting. And so on this one is an 80-20 split. You'll see that tender number 6 has the highest technical consideration. So from a technical perspective, that's the best solution, but it is the highest price. And so when we come to look at the overall picture, we take the score from the technical and the score from the financial, and we see that the best score, and it's very close, is tender number 6. So even though it is the most expensive, it is the best technical solution that sits there, but it's not just looking at technical, it's looking at technical and price, and the weighting is set to reflect the nature of the complexity of that procurement. Now, it may well be that you would actually say, well, this is a relatively straightforward, it's a standard layout, it's a common design, etc. Therefore, the technical issues shouldn't be on an 80-20, it should be on a 60-40. But that weighting would be made known as part of the bid document to say that we're looking at this on the basis of a 60-40 split in terms of quality and price, and in terms of the technical things, these are the things that we'll be looking at. So you can see what all of those would be, and then it can build it through from there. But there is the broad outline in terms of that sort of matrix, but again, it will be firmed up based upon the individual circumstances there. Does that answer your question? Tabilio. Thank you.
Yes, definitely. Yes. I mean, that's a really good orientation, because sometimes what happens is that we tend to be very intuitive and less rational, and because there's so many factors that it's really difficult sometimes.
Yeah, but
Okay.
and what this does is it sets people thinking about it before they start the procurement, knowing that they can't change it after they've started. And if they get it wrong, the implications are they then have to go back and start the process again. And nobody wants to start the process again. And so having this as a methodology, one, it adds rigor, it adds consistency. It also hopefully will give you as suppliers the confidence that your submission has been evaluated in a sensible way, and that whatever decision comes up, whether you're successful or not, and if you're not successful, then clearly you'd be disappointed, but at least you can recognize that you've had a fair evaluation of your submission, rather than, well, maybe they had already decided who it's actually going to be, because that won't actually work anymore.
Understood.
Excellent, thank you.
Thank you.
The one thing I would add, and perhaps this raises a question for Rob as well, because I don't know how to answer it. But one of the things is you have to disclose at this time not only the weighting, but also how you apply that weighting. So for example, in terms of price, it could be that the lowest price gets 100, but then how do you determine what the weighting is and the score for the other levels of price? Is it a linear thing? Is it, you know, the top one gets 100, the next one gets 80, the next one gets 60, or is there a more complicated, sophisticated method? You have to disclose that, but that, depending on how you do it, will have a dramatically different effect on the ultimate scoring. So Rob may be able to explain how.
Yeah, it just sort of follow on. So if you take 1 to 2, so 1 is 1.2, and so 1 million divided by 1.2 will give you 83%. And so 1.2 is effectively 17% above the lowest price. Therefore, you get 83% of the score. So 100% is 20, 83% of the score is 16.67. So the price is more expensive. You take it relative to the lowest price, and therefore that determines your score. And you do exactly the same with the technical consideration. So you'd see all the scores that they get, and you would then rank that score relative to the best one. And so from a technical perspective, the best is 6, so that gets 100%, which is 80. The next gets 93, and 93 of 95 is 97 points, so they would get a 97.89% of the total. So 97.89% of 80 is 78.32, and so on will be the methodology that would apply. So it's a straightforward assessment against the same criteria, the scores that each achieve, that then predetermines what the final score will be when you bring it together based on the combined weighting that applies.
Sorry, just a last question. Talking about this, sometimes it could be really difficult to visualize. Is there any formula, or there any explanation of what you just have said to just digest it a little bit slower?
Yes, yeah. I say this is always a complication that we face is that we have a fixed time span to be able to do that. But yes, and you can actually sort of work. So if we take the technical consideration, and what I would do is, and I would offer this to Dr. Glasgow to circulate out to you all. So if we know who's actually here, or you express confirmation, is I will put together a formal written methodology in terms of how I've actually gone through this, if that would help.
Oh, yes, definitely. I wasn't expecting an explanation now, but exactly that's what I wanted to see if I can, you know, or you could tell me where to find it. But if you can send that over, that would be great, because I mean, then you could study it more in depth and then clarify things. I really appreciate that.
You're welcome. You're welcome. All we have to do is agree what the cost is.
Okay.
I'm joking. I'm joking. Okay, so that's the sort of process that we're actually talking about, and that's what the Act itself requires in terms of discipline from a procuring entity to be able to do that. Because in the same way that you just said, is like, how do we actually sort of get there? Is when we come to debrief. So if I'm bidder number one, then I can say is, well, hang on a minute, you know, I know when the tenders were open, I was the lowest price. Therefore, why have I been unsuccessful? And you can actually say is, well, in terms of your technical one, is your submission had a longer time span to be completed by, in terms of the experience that you got, you didn't have experience with the same number of people. And so you can say very clearly where you need to improve and what you need to do differently. But it is only what you need to do. It's not saying is, well, the one who won it had this, and this, because that would be a clear breach of confidentiality. But what it does provide is the procuring entity with the necessary information to give to you to say, next time, these are things that you need to consider to improve in order to be successful. And in all honesty, that's what I want you to do. I want you to be more successful, because the more successful you are, the greater the competition is, the better the value for money that I will get from the outcome that from that. And so it's in my interest to make sure that you fully understand what you need to do differently in order to improve your chances of success next time. So I will put something together and see Dr. Glasgow can circulate that through. So again, lowest price, and want to stress it is there as lowest price, but think in terms of most advantageous tender to be the ones that we'd use. And giving the list that I've seen here, most people would feel more comfortable that we actually look at most advantageous tender rather than lowest price. So what we can also do is, because remember, we can look at if as part of the aggregation, we've got this concept of multiple lots. So we may well say within this sort of process is we may well be looking at different suppliers within that. So most advantageous tender may well be is that we award one bidder 3 lots out of 5 because the unit cost drops such where we have multiple lots awarded that it actually makes that. However, if we've got 2 bids coming in for a particular lot, which is the same, then we can actually say, well, what we can do is we can actually share this lot. So rather than it be a single supply, is we'll actually share this lot, and we'll have a standard rate and a standard pre-qualification in terms of how do I choose as a procurement entity, which one I use. And it may well be that, and if we think in terms of the framework agreements that we set up, is in the event of an emergency or an urgent requirement, is we can go to one, and if one's got it, great. If they haven't, we can go to the other one. So it gives us that flexibility to be able to do that, and we know that we're not going to be disadvantaged. And equally, suppliers know that it's in their interest to make sure that they have the things available in order that they can then satisfy that need that has to go through. And so in terms of the award, everybody who's unsuccessful gets to know first. So they know who's won it and they know what the value is. They can then make their challenge within the 10-day period. And it's only after that 10-day period that the award notice goes out. So the supplier may know that they've won it subject to no challenge coming through within the standstill period. And failure to comply with any of the things that may be in there. So if you said, right, we've agreed, this is what's going to go, and the supplier who is confirmed as being successful for whatever reason doesn't sign the contract within the timescale, so they may well be having to get financed, and the finance doesn't come through, therefore they can't sign it with the timescale, or if the performance bond has difficulty in being set up within the timescale, then what the procuring entity can do is they can select the next best valid tender. So going back to the exercise that I did, is they could look at that and say, okay, the best one would have been tender 6, but we can't get the performance bond, or they've hit problems in terms of being able to finance the deal, etc. Therefore, we'll go to tender number 5 as the next best one that comes through. They can't just suddenly decide, oh, right, okay, so number 6 can't do it. Let's choose number 1 because that's the one that we really wanted it to go to. So it has to be against the criteria that they've done to take the next best. So it can become descending order in terms of performance against the evaluation criteria. And equally, if the first one fails, the second one fails, you may well look at the third one. If the third one fails, then my recommendation that there is something strange going on here, and to award beyond that point is likely to lead us with the poor contract that we're actually doing. Right. Sorry, I've just got I've just seen another chat. Forgive me. I apologize, but why is technical weighting worth 4 times price weighting? Is this a fixed ratio? No, it's not a fixed ratio. What it would be is depending upon the nature of the contract, and it may well be that you're actually looking at something which is highly innovative. So BVI wants a new government headquarters and wants to demonstrate that the element of British Virgin Islandness, for want of a better phrase, is epitomized by this sort of building. Therefore, the technical thing in terms of using innovative materials, using innovative design, etc., far outweighs the price. Price is still important, but it's not the main driver within that, because the procuring entity said this is what we want it to be. It wants to be an iconic building. You know, if you take Sydney Opera House as a sort of classic example, is price. If price had been the key driver on that, it would never have been built. And so it's about saying this is what we as the procuring entity see as being the criteria. And it could be 4 times, it could be 3 times, it could be 2 times. But they have to be able to demonstrate why it is the weightings that they've applied. But they will then, having set those weightings, apply them consistently across each of the bids that actually come through. So you will know in advance, right, this is what it is, this is how the weighting is going to do. Therefore, when I put my submission together, I'm going to put it in the way which will maximize my results against the criteria that we've got. So you know the criteria in there, and therefore you're in the best position to be able to align your submission to those criteria to get the best outcome. And that's really the benefit for both parties, because if you can do that, that means we're getting the best value for money against the criteria profile that we've put together. Does that answer your question, Robert? Okay, well, if you can come back to me as part of that, that's fine. So I say, so there is a rationale in terms of the awarding. You can't just, if the first choice one fails for, say, in terms of performance bonds or whatever, you can't then just simply choose anybody from there. There is a rationale and a hierarchy within that. Okay, thank you, Robert. There is a hierarchy that actually sort of sits within that sort of base. And again, operationally, I would say is, if you get beyond 3 who fail to sign off on the contract, then that would ring alarm bells for me, and I would revisit the whole sort of process, because it may well be to continue is likely to ensure I end up with more issues than I want to deal with. And then once we've gone through the standstill period, we publish the award in newspaper or on the government website, or both, or internationally as appropriate, so that everybody can see what's actually happened. So that's a sort of practical side. Now we get back to, right, so having gone through all that, having seen all that sort of stuff, there's unlikely to be any questions in terms of challenges or whatever. But on the off chance that there may well be, then the law itself does allow for those sort of things in there. And then we have no one better to deal with those than my colleague, you, Peter. So away to you go. What happens when the law's been breached? You're on mute.
So the question is, what happens to the procuring entities in BVI who haven't been listening to Rob's advice and making this clear and consistent and in compliance with the law? So where there is a breach, you as a supplier have a possibility to bring a challenge. And before I go into the actual process, just to say that this really is quite important that bidders are given the challenge, because traditionally what's happened is governments have tended to have sort of supervision or checks and balances within the government, so that they really try to check what's going on each time the procurement has taken place. But that's quite extensive in terms of time, and can cost quite a lot in terms of having to look at every contract award procedure. Now in BVI, that's not excessive because there's still a limited number of contracts being awarded, but nonetheless, across all the ministries, still a significant number. And so it is quite time consuming to try to review all of those, especially where in most cases, hopefully, there won't be a breach. So you're reviewing and checking and going up the hierarchy to review contracts where there's no need because there is no breach. So one of the things that you see in modern procurement systems is really a move away from this sort of hierarchical supervision towards a bidder-driven complaint mechanism. Because to be honest, if there is any problem in the procurement procedure, the one group of people that are going to notice that and are going to identify it immediately are you, the bidders. The supply community is the one that's going to see those, because you see the advertisement, you see the days that you're given, you see the documents, you see the specifications. And so you're the ones that are best placed to spot any problem. And that's why it's really become the modern way really of making sure that enforcement takes place properly and that people comply with the law. So I just want to emphasize that this is not an accident. It's not just, oh well, let's give suppliers the possibility to bid. This really is the way in which enforcement will take place best. And it's also the message that we're giving to government as we're doing training for the government, to make sure that they understand that this is a very sensible and very effective way to ensure enforcement of the legal framework. So you as the suppliers, I think you're in the driving seat, and it's very important that you do take up this opportunity given to challenge any potential breach of the procedures. And so you have effectively, well, I mean, we've put in there are 3 levels, but effectively there are 2 that we would like to emphasize. And the first one is that you would request a review from the procuring entity. And the reason you would do that is that maybe if there's what looks like a breach of the procurement rules, maybe it's a simple mistake. Maybe they've missed it, they haven't spotted it, and maybe somebody in the administration, you know, if they're supposed to give you 40 days or 35 days in order to submit your bids, and somebody writes down 34 days, well, clearly that's a breach of the rule because it's not 35, but that might just be a mistake. It may be a clerical error. And so going to the procuring entity and saying, hey, look, we think you haven't given us the right number of days here. Would you mind correcting it, and telling everybody that they have an extra day to deliver? That would solve the problem, even if it is a simple mistake. And I always think that's a very good way of starting any review process, because it's not confrontational, at least, unless you write a very nasty letter. But the idea is that if it is just a mistake, then without having litigation and without having a controversy, you can simply try to correct that mistake. And that's really the best way through it. If the procuring entity thinks that there was no mistake and that the reason, whatever they've done deliberately and with you know, and they've thought about it, then they might just reject it, or they could ignore you if they're really not willing to concede anything. So if you don't like the answer they give you, or if they don't give you any answer at all, then you have the opportunity to go to an independent body. Now, this is not independent of the government, obviously, because that would require setting up a wholly new institution, but it is independent of the procuring entity. So it's not going up, you know, to the bosses of the people who may have made a mistake. It's going outside that and trying to get some independent, or an independent as possible review of the potential breach, and that they will make a decision then on what the nature of that breach is. We'll go a little bit into detail in a moment, but one of the things to remember is that any request for a review, anytime you make a challenge, gives rise to an automatic suspension. So the procuring entity cannot proceed, at least not proceed to the award of the contract, while any challenge is taking place. There are exceptions, and we'll explain that in a minute. But anytime you make this complaint, and you have, as we discussed already, you have 10 days within which to make this complaint. That's called the standstill period. So once you're notified of the intention of the procuring entity to award the contract, if you spot something before, you bring an action earlier. But at the very latest, if at the point that they send you the notice of intention to award a contract, you see that there's a potential breach, then you have 10 days in which to make the complaint. And in those 10 days, there is an injunction in place. There's an automatic suspension, and that stays in place until the end of the complaint procedure. So until you have a final say on that complaint. So why don't we go to the next page, because the next slide, because I can see that actually deals more, it says a little bit more, it writes out more than what I've been saying, which is whenever the challenge is made. So it doesn't say that there is a suspension, but what it says is the procuring entity may not take any step that would bring into force a procurement contract or a framework agreement if they're doing that in the procurement proceedings. So they might be able to proceed. It depends at what stage this is. I mean, if you do this at the award notice, then they might be able to, I mean, the deadline for submission, that sort of period, or looking at rejection of tenderers, they could still proceed a little bit with the process, even if you have put in place a complaint, but they would never be able to award a contract. That's something that they can't do, because that would remove any possibility of providing a meaningful remedy, because you don't want damages, even if those are available. What you really want is to see that the contract is awarded properly. So for all of those reasons, you have this suspension in place, and the suspension will lapse either within 3 days of the decision being communicated. So if that's the procuring entity saying that's the end of it and you agree, okay, they can then continue 3 days later. If it's the Procurement Appeals Board, the same thing happens. You would then, you know, that's how long the suspension works. Or, and this is an important caveat, and this I said was the exception, is that if there is urgent public interest, so let's say a bridge has collapsed, well, really you need to repair that as soon as possible. You can't hang on too long to hear the dispute, or if you're looking for medicines and there's an urgent need for that to come, then the procuring entity can make the case that the suspension should stop and that they should carry on with the contract award procedure. They have to justify that, and they will have to go in front of the Procurement Appeals Board to ask them to lift the suspension. So that would have to be done on justifiable grounds. I mean, it's a balance. Do we really, you know, if this looks as if there is a breach, then should we really allow them to award the contract? On the other hand, we may need to award the contract, even if there is a potential breach. We haven't worked that out yet because we haven't looked at it. So it has to be weighed in the balance. But there is this possibility of asking the Procurement Appeals Board to lift the suspension in the case of urgent public interest. And no legal system doesn't cover that. So that's always covered, because there are cases where you really do need to proceed with the procurement. I should also mention, and this is on the next slide, third-party rights, because clearly it's going to be a particular tender who spots the potential breach and who wants to bring the proceedings. But there is it may be that lots of other tenderers have the same problem. And so what needs to be done is that the notice of the challenge is sent to all the tenderers who are participating in the contract award procedure, and they have the right to participate in that challenge. So they will be told that there's a challenge in place, they will know what it's about, and if they want to, they can elect to join in that challenge. So they would be another party, or they would be a third party listening to the proceedings, and they could add their own arguments to the extent that they want to. That just is an efficiency issue. It makes it much easier if many people have got the same complaint to hear it at the same time. It saves costs and it saves time. And if they don't join in those proceedings, then they can't later bring a complaint on the basis of the same potential breach. They could do it for something else, but if they want to raise the same matter again, they're barred from doing it because they had their chance of doing it. And again, this is really an efficiency issue, but one which is quite important to be aware of. So if I go on to the next slide, the basis of this right, so the right of bringing the challenge.
Did you forgive me, Peter, if I missed something? Is that, and I don't know whether you mentioned, is that if they choose not to participate, then they can't subsequently come on and say, "Oh, by the way."
Yeah, absolutely.
In which case, sorry, I was just answering something else.
Yeah. Okay, so if the procurement proceedings aren't cancelled, obviously, then a bidder who suffers or is likely to suffer loss or injury due to a breach. So this is not an industry association, for example. It's got to be the bidder who is interested in the contract and as a result of the breach might actually suffer damage, i.e. fail to win the contract. Then they can bring the challenge. First of all, as we've said, they must firstly file the notice with the procuring entity. That's the first stage of the procedure. And then the procuring entity, as long as it, once it's reviewed, it can either say, yes, that was wrong, and this is what I'm going to do about it. So it will say, I'm going to correct the mistake, I'm going to reissue the solicitation documents, or I'm going to change the date for submission of bids. Whatever the fault is that has been found, they will say, this is how I'm going to deal with it. And if they don't want to do that, then within 10 days of getting the complaint, they can dismiss the challenge. So they will say, we're just not going to look at it. And this could be done if they think the complaint is frivolous. So if it's just made to cause a problem, if it's just made for, for non-good reasons. You have to be able to, if you're a supplier, you have to be able to say, well, I think there's been a breach, and this is the article of the law, the regulations that's not being complied with. You can't complain just because you don't like the result. If they say, oh, well, I think we should have won, not the other people. That's not a grounds for complaint. The only way you can complain is if they've breached the law. So you have to point to a breach of the law. So you could say, well, they won because the specification was biased in the favor of the winning bidder. Okay, so you said they breached the non-discrimination principle, the requirement in the law to be neutral in terms of specifications. That's the ground on which you can challenge the decision. But you can't say, oh, well, they just preferred that one to ours. Well, obviously that's not right because ours is better. That's not a ground for complaint. You have to point to a provision in the act. So that would sort of be a frivolous complaint, or one not made in good faith because you're trying to. Let me say one of these things, this idea about not in good faith, and this is one of the problems about having an automatic suspension. To be honest, I'm not a great fan of automatic suspensions, but it happens in most countries in the world. So I'm almost alone in saying that I don't think it's a good idea. But I have a reason for saying that, and that is that if there is an automatic suspension and the procuring entity is not then permitted to go ahead for the award of the contract, bringing the complaint will stop the procurement procedure. And quite often, a supplier might want to do that just to hold them hostage, might say, well, I'm going to stop you awarding the contract, so just give it to me and then I'll take away my challenge. And I came across this in Romania. I mean, But Rob might be interested in this. We were in Romania, and there a trade association was permitted to bring a complaint. So here in the BVI legislation, it's only the bidder. So we're already not in that territory. But there, the trade association was allowed to bring the bid, and I was interviewing them because I was trying to see how well the system was operating. And I said, I asked, do you or any of your members bring complaints? And the answer, which I wasn't expecting from the trade association, was yes, we bring a complaint in every case.
Mm.
Every time there's a procurement award procedure, we bring a case. Really? Says yes. Well, then we can negotiate with the procuring entity which of our members is going to win the contract, because they knew that once the complaint was brought, the whole process came to an end. And in order to make the thing move forward, they would have to negotiate with the procuring entity, would have to discuss with it. And because they were the trade association, it was less easy to pin, to say, oh, well, it's this contractor that's causing a problem and acting in good faith. The trade association could do that and say, well, I'm just acting in the interests of my members. Clearly, it was the way to operate a cartel, a bid rigging exercise. But that's one of the reasons I don't like automatic suspensions, because it does hold hostage the procuring entity to some extent. But here it's limited in time, and you can lift it in the right circumstances. So there is enough to palliate. And because it's the bidder who suffers or likely to suffer, that is the only one who can bring the bid. And I think that situation that I came across in Romania is unlikely or very difficult to see happening in practice. But just bear it in mind. I'm not suggesting that you should go and hold the procuring entities hostage and come up with a method of doing this. But just there's a sensible way of doing this and a non-sensible way. So if you're just bringing complaints for the sake of it, if it's frivolous, if you're doing it for some ulterior motive, then you're not going to succeed. And just be aware that really you have to identify the breach. And if it's serious, then by all means go ahead with it, and hopefully the procuring entity and then the procurement appeals board will take that seriously. Devoid of sufficient grounds, of course, as I've said, you have to say what the grounds of the complaint are. You have to identify the relevant article or article of the law or the regulations, and you need to support it with evidence. So you have to not just say, well, I think this has been breached. You have to say, well, this has been breached because, and either, let's say it's the number of days, well, you give them the advertisement which sets out the number of days. If you say it's a discriminatory specification, you need to provide the specification, which is in the documents, of course, so you can just say, look, this is discriminatory, and provide evidence of why that's discriminatory. So Rob gave the example, if you just cut and paste the specification document from a previous supplier, then clearly it's the one that's designed to favor that supplier, because the specifications are drafted by them, if that's what you've done. So then it's very easy to say, well, these are the specifications the government the procuring entity has given, and look, these are the specifications of the winning tender, and they're identical. So there's clearly there's clearly been some cut and paste, and if that's accepted, then obviously that's where you win, you're successful in your case. So you need to be serious about the case. You have to provide an indication of what article is being breached, and then you need to support it by evidence of probative value. So that's good, not just something somebody said. You actually have to have evidence for it. And if all of that happens, then normally that would be the way through. So on the next slide, I'm sorry if some of this is repetitive, but it's good to get the whole idea in place. So we've said who can bring the action, and we've said it takes place in 3 stages, and I've explained already the first one, which is the application for reconsideration by the procuring entity. If you're not happy with that, or if they refuse to give an answer, as I've said, you could then make an application for review by the Procurement Appeals Board. And then we have the third one, which is an appeal to the High Court. Now, this isn't one we hope will ever be taken, but if the Procurement Appeals Board, as the second stage of appeal, has misapplied the law, because there is a lawyer as the chair, but 2 of the members may not be lawyers, and you never know, they could be trying to apply a policy decision rather than a legal decision. If they have made a mistake on the law, then you as the supplier, or even if you win the case and the procuring entity thinks there's been a mistake on the law, they can make an appeal to the High Court on that point of law. So it's not to rehear the whole case again, it's just to say, please give us an answer on this issue of law. You're the court, you tell us if we've got it right or not. So the 3 stages there. I'm a lawyer, so we don't have all these diagrams. Rob's got lots of diagrams, but I have tried to put in a little diagram here. So stage 1 is the complaint of the procuring entity. Stage 2 is the administrative review by the Procurement Appeals Board. And it's called administrative because it's not a judicial one. It's not done by a court. It's a quasi-judicial forum, if you like. They act as if they're judges, but they're not actually judges. And then the 3rd stage is the appeal to the High Court, as I've said, on a point of law. In terms of the timetable, which is the next slide, in terms of the timetable, the procuring entity has got to notify the challenger within 10 days of its decision once the complaint has been made. So you complain, the procuring entity has 10 days to answer. And if the challenge has been dismissed by the procuring entity, or if you don't like the answer that the procuring entity provides to you, then you can make the appeal to the next level, which is the Procurement Appeals Board. And of course, the decision of the procuring entity has got to form part of the record, the record you have of all the procurement proceedings, the paper trail of the procurement, if you like. So the decision of the procuring entity has to be put in those proceedings, in that record. And the next slide, please.
That one.
Look, that one. Okay, right. I'm sorry. We do keep saying the same thing all the time.
I had a fat finger at that stage.
So the application for a review. So the procuring entity has 10 days to provide its answer. We've set out the reasons why you may want to appeal that. You then have 5 days to make an appeal to the procurement unit in order to get it to the Procurement Advisory Board. Now, you may be wondering why the procurement unit has suddenly appeared here, because they're within the Ministry of Finance, and they, for anything above $100,000, they're actually the ones responsible. So they may be the people against whom you're complaining. The reason we have this is the Procurement Advisory Board is not a permanent body. They're not full-time. They're not sitting there waiting for you to bring complaints, and they don't have an office, and they don't have a secretary, and they don't have a driver. They have nothing. They're just called in to deal with a complaint as and when it happens. So somebody has to do the administration. Somebody has to receive the complaint. Somebody has to register the complaint. Somebody has to send the complaint and the documents to the Procurement Advisory Board. Somebody has to tell the Procurement Advisory Board that they've got to wake up and do something, because until they get the case, they've got no role at all. So the procurement unit is involved only as a logistical device, so that when you have a complaint, you can then send it on to, that they can send it on to the Procurement the Appeals Board. And the procurement unit will inform the Procurement Appeals Board and the Minister at the same time, so that everybody is aware that this complaint is going on. They will also, I should add here, they will also notify all the other bidders in the procedure, for this third party rights provision, which is everybody can be informed. So if they want to participate in these procedures, they will be told that it's happening. And then within 10 days of that, there is a bit of time here, but this is because the appeals board needs to be constituted. It's not a permanent body. So that it says here, the minister will within 10 days forward the request to the appeals board. That sounds as if it's going to take him 10 days to write the letter and send it. Actually, it's going to take 10 days to identify the appeals board, make sure they're available, set them up, find a replacement if somebody is not available, and then give them the dossier, the full documents that they need on which to make their decision. So it sounds a long time, but there's a lot of stuff that needs to be done in that period for them to get it. And then they will decide on how it is that they're going to hear the review, whether there's going to be a hearing, whether it's going to be done on paper and so forth. So on the next slide, we can see a little bit more about the process. So the Procurement Appeals Board will serve a notice of the challenge and the documents on, sorry, this is the point, sorry, excuse me, this is the point at which the other bidders find out, the other suppliers find out about the case. It's the Procurement Appeals Board that does it, not the procurement unit, forgive me. I was jumping ahead of myself. They will also notify, sorry, yeah, I'm sorry, that's saying the same thing. I think we've overdone it on the slides.
Okay.
So they will make the necessary notification to all the bidders to say, if you want to join this procedure, you can. Also, any government authority who might be interested in this, because it could be a common type of procurement, and they will also tell any bidder, if you don't participate, then you're not going to be able to come back and make the same challenge in future procedures. So I've explained all of that, but this is the point at which it happens. I'm sorry, it's the Procurement of the Appeals Board that makes the notification. This is all new to us as well. It's a brand new act, so we're going through it as best we can. So on the next slide, please. Now this is not yet fully set out in the Act. I believe it's going to be set out in the regulations, but they're not finalized yet. They're going to be adopted very shortly. But once you've got the Procurement Appeals Board, they're going to make a decision. They're going to decide what the result is going to be and how they're going to remedy the situation. And so the most obvious thing that they're going to be able to do is to stop the procuring entity from making a decision which is going to be in breach of the Procurement Act or the regulations. So in the challenge, you would say, you know, for this reason, we think that they can't award the contract to X because it's been made in a discriminatory way. So what the appeals board can do is to say, okay, you may not award the contract. Okay, so they can stop that process going on. They can annul in whole or in part an unauthorized act or decision. Now, this in many countries is called a set-aside, and I find this quite an important remedy. Let's go back to the example we had about possibly a discriminatory specification. What they can say, if the challenge is made to that specification and they agree, they'll say, oh, well, this one is biased. So what you can now do is make it unbiased. So you can either change it or replace it with a specification which is neutral. And then you can carry on with the procedure, with the contract award procedure. So, I mean, it's a nice remedy because it allows the whole of the procurement process to continue. There is a hiatus while that happens, but you don't have to start all over again. There is no huge delay. You can simply correct. I mean, even simpler if the dates are wrong. If the date says, you know, it's 34 days, not 35, then the Procurement Appeals Board can say, okay, so we annul the 34 days. And then the procuring entity will say, okay, well, we'll take away the 34 days and we'll do it 35, which is what we're supposed to do. So it's a way of making this work fairly smooth, as smoothly as possible where there has been a complaint. If they annul either the whole thing or a part of it, they could then say, you know, we order a new contract award procedure. So you retender, you start all over again. And finally, this, I'm not sure if it's going to happen. This has to be discussed at the cabinet level, but maybe there's going to be compensation for the successful bidder, because of course he's failed to win the contract as a result of a breach. And of course he's paid for the costs of preparing the bid and everything. And so in many countries, you would find compensation being paid to the procuring and the supplier, the successful supplier, for that reason. Some countries don't like it because governments can't afford to pay this. So there is a question mark over whether this is going to happen or not. But that is one of the solutions that you would normally find in different countries. This is still not settled yet, and the cabinet and the government have to decide. But these are the sorts of things that you can expect to see in terms of the remedies that are available. The one thing you will see here is, or not see here, is the possibility for the Procurement Appeals Board to make the decision itself. So they're not going to say, oh, there was a breach here and the answer should have been X, because that would mean they were acting in the same, they would put themselves into the position of a procuring entity, and that's not their competence, that's not their jurisdiction. Their job is simply to say, there was a breach, yes or no, and this is the consequence. So there's no point as a supplier going to them and saying, well, I think this was the wrong decision. They really should have chosen us. You can't go there and say, sorry, that was the wrong decision. They should have chosen us. You say they should have chosen us. That's not at all what the Procurement Appeals Board will do. They don't make procurement decisions. What they do is decide whether, in making a procurement decision, the procuring entity has acted within or outside the law. That's solely the reason they exist. So don't expect them to give you a different procurement decision or to replace the decision of the procuring entity. They can say, no, this was unlawful, go back and do it again. That's as far as they will be able to go. And it's quite important. That sort of stops also frivolous cases where you just want another crack at the whip. So you try to stop that as much as possible. The next slide seems to be, I'm sorry about this, seems to be a repeat of what of what I've just said, the different types of action that would be available. So let's just skip on to the following slide, and this is not anymore the challenge procedure. This is simply raising the question of supplier disqualification. And this is what Rob and I discussed a little bit earlier when talking about debarment. So there are grounds that would, I mean, first of all, you can be just disqualified from the procedure. So if you submit false, materially inaccurate or incomplete qualification information. But if you go beyond that, then this becomes a criminal offense. So if you try to interfere with the participation of other tenderers, if you commit fraud, if you have a corrupt act or you harass other tenderers, if you're colluding with other tenderers to falsify the market and fix prices or fix market shares or so forth, then that's also not so much a criminal offense, but an offense of serious professional misconduct. The non-signature of the contract, well, I wouldn't really call that disqualification. And non-signature is really, that's one of the reasons you have a tender security. So I wouldn't include that necessarily as part of a supplier disqualification system. But also you may be convicted of a criminal offense related to corruption. It's not a speeding offense or a parking fine. It has to be a criminal offense which is linked to the procurement process. And so for any one of these reasons, you might not just be disqualified from a particular contract award procedure, but you could be debarred from participating in other contract award procedures for a specified number of years or a particular time. That hasn't been decided yet. That is going to be part of the regulations when they're adopted, but you'd be looking at things like a not a suspension, but a bit like a suspended sentence. So something that says, well, we're not going to debar you now, but you have to do something. You have to correct what you've done. You have to put in place a compliance program. You have to take disciplinary action against the people in your company that were corrupt, because maybe it's not the tenderer that's corrupt, but something happened by one of the staff. So you have to take disciplinary action. And so that's the most lenient result of going through a debarment procedure, is they would just say, well, this is a warning. We will debar you unless you correct X, Y, and Z. And so that's probably the best solution for a supplier. If it's a more serious offense, or it's the second time or third time that the offense has happened, then there may be the first level of debarment, which could be 6 months, 1 year, 2 years. It depends on country, that they have different levels that they want to apply. And if there's particularly egregious offenses, if it's a really bad case of corruption, and it's certainly not the first, then it could even be a higher level of debarment. But that's, again, something that would be discussed. In some countries, but very few, there can be a permanent debarment, which is that a tenderer could never participate anymore. But that's really very dangerous, because what we're trying to do, what you would normally try to do through debarment, is to warn people and try to bring them back into line, to say, look, this is not acceptable, get your house in order, and in 2 years we'll allow you back in. And that, you know, it's a way to improve and correct any problems. To debar people completely is really such a serious penalty that it's rarely used. And I think, as I mentioned before, in small economies, I mean, in terms of the number of people involved, then you don't want to get rid of one of the few suppliers that you've got. So, you know, it would be too drastic a remedy. So I suspect what's going to happen is that there will be a series of levels of debarment depending on the severity of the offence, but it probably will never be a permanent debarment. And this is, at the moment, this is set out as going to be a debarment within BVI. But it's possible, because they do have this thing, and the multilateral development banks have a process that they call cross-debarment. And that is to say, if we have debarred our bidders from our contracts, we expect you, another bank, to also do debarment from your contract award procedures. And sometimes these MDBs apply them within national countries. It's possible to do that at a national level, but if you do, you have to be fairly confident of the debarment procedures of any other jurisdiction that you apply. So if you said, you know, anybody who's been debarred in BVI or any other country, you'd have to know what the debarment procedures are and be comfortable with debarment procedures in all those other countries.
And they all have to be consistent.
And they all have to be consistent, exactly. And sometimes you can't really guarantee that that's done properly. Hopefully in BVI it will be done properly, but you don't know in a neighboring island or in a different country whether it is done with the same rigor and as well as here. So I would be nervous about introducing cross-debarment until I'm pretty sure that that can be assessed properly and can be applied fairly. So all of this is a little bit up in the air at the moment. I mean, the cabinet will be discussing it, but I think what's clear is that there will be a debarment procedure, there will be penalties, but it may not go as far as you might see in other countries. Rob, you wanted to say something?
No, all I was going to say is that in terms of this one, is again, it requires a degree of consistency of approach, because inconsistency means that any action in terms of debarment is then put under threat, because the argument could be is, if I'm good enough in Grenada, then I should be good enough in BVI. If I'm good enough in St. Lucia, I should be good enough in wherever. And so it does bring a degree of consistency, which is very difficult to deliver. And so I think what will tend to happen is that as an element will wither on the vine, because from a practical perspective, it's not capable of being delivered in a consistent fashion.
And I see that we've got overexcited with the next slide as well, because this fundamentally is the same thing. The only difference with this is that when you see at the end, this really shows that the debarment procedure, not suspension, that's a different issue, but it shows that debarment has to follow a procedure which provides due process. So it isn't a procuring entity that just says, oh, we didn't like the way they performed the contract, for example, so we're going to debar them. Bidders have to be given a notice in writing as to what the grounds for debarment are that the procuring entity or central body is relying on. They have to be given a reasonable opportunity to respond to those grounds, and they must be given the evidence they need, the information they need on which to base their defense. And the result can only be, the decision can only be made following a proper investigation of the facts. Now, on this slide, it says by the procuring entity. It may not be the procuring entity. It may be the Central Tenders Board or a committee that's set up. It's quite dangerous having a procuring entity make the decision, because quite often they make it for their own subjective reasons. And what you find in most countries, and I suspect what might happen here, because the role is given to the Central Tenders Board in the Act, is that the Central Tenders Board would set up probably an ad hoc committee to investigate any alleged ground for debarment, and then they would conduct this process and do this in a way that is fair to all the parties. So as I said,
but I think that the last point is there is really to say to the procurement entity is, look, you cannot just simply on a whim. If someone makes a challenge, you have to treat it seriously. You have to look at it. You have to have a proper investigation in terms of facts, because those are the facts that will be submitted to the appeals board or the central tenders board or whatever for consideration. So if it's incumbent upon them to make sure they do a proper job, because otherwise the likelihood is that that will delay the process even further, or it's more likely to stop the process, because if they can't get the information, they can't get the evidence to be able to determine one way or the other, natural reaction is to say stop, because the risk is too high, because government itself is predominantly a risk-averse organisation.
Okay. So is there any question on the challenge or the suspension? I think Rob is then going to go on to just some final provisions which are important in looking at the procurement processes.
Sure.
Any questions on any of this so far? Okay, so back over to you, Rob.
Okay, great. So just really to sort of tidy up on some of the things that that we need to sort of just sort of bring in, which hopefully sort of simplifies and clears up some of the potential loopholes that have been there. In terms of cancellation of public procurement, which was a concern that certainly a number of suppliers have said to me, is that we never know if public procurements have been cancelled. Then now within the Act, it is incumbent upon procurement entities to confirm where public procurements have been cancelled, and also to provide reasons why a procurement failed, and to have a lessons learned which says, let's not do this again. In the same way that you can have one emergency, but if you don't learn the lesson of that emergency, you can't then rely upon that same grounds a second time round, because you can say, well, hang on a minute, this has happened before, therefore you should have made suitable steps to avoid it happening again. So cancellation of public procurement now needs to be notified, and we circulate it out to people to actually confirm the reasons why. In terms of records of public procurement, so why they failed, where we've had no responsive bids received. So again, if we've been out and no one's come back, then invariably the procurement can't proceed, but we need to look at it. Why was that? What was the reason why no responsive bids were received, and what do we need to do different? So is it a policy? Do we need to issue guidance? Do we need to revise the code of practice, or whatever it may be? So that action will need to be taken potentially in order to make sure that we don't go through futile exercises where we do a bid exercise and it just wastes our time as well as your time. We need to record where, for whatever reason, operationally or maybe just policy decisions, that we no longer require it. So we may well have put in the annual procurement plan that we're going to be buying whatever it may be, but equally we need to record where that change occurs and the reasons why we're doing that. Also, where we're using anything other than the open procedure, that there's a full justification of that, and that goes down with each individual procurement. So again, we've almost got what you would see in sort of criminal terms is the evidence book. And so you've got a track right the way through of each estate. Every piece of the jigsaw is included within that, which includes there. Also a contract register, so we can see what contracts have been placed within that timescale and that they actually match up with what we identify as part of the original procurement plan. And anything that differs between the contract register and the procurement plan should be met by either cancellations or notification as to why we've done something different. All awards made, so that again there is a full record of all procurement awards that are made. And in terms of any declarations, so where we've got information that's come through that those declarations have been validated. So remember the bona fide note that actually goes with the bid document, which actually says, yes, I declare that I've not involved in collusion or any of those factors, that we actually do check that that is the case. In terms of payments, so again, any payment that's made needs to have evidence, and within the act, it actually sort of identifies who can sign those off and what is actually needed. And it's incumbent in the bid document to determine what that is. In terms of advance payments, so advance payments should not be taken on board and should be avoided where possible, unless they have some kind of guarantee within that. In terms of variations, again, variations where they are allowed within the contract. Again, there are thresholds, so ensuring that if variations are above the thresholds, and if it is 15% or 14% variation and the accounting officer signs it, he doesn't have the authority to sign that off. So you're aware of what the authorization levels are. So if the variations come through, the appropriate person is able to sign those off. And then finally, to record in terms of performance standards, so hence the push to achieve a performance-based specification methodology, and those performance standards are identified right the way through, and there is a clear line from starting the bid process to completion of the contract, and we can determine that the performance standards have been attained, and therefore payment is made against those standards and those requirements within the specification. And indeed, in terms of monitoring, so the nature of the procurement unit is to also monitor the activities within the procurement committees, within the procuring entities, to make sure that there's no inconsistency in terms of interpretation, and where opportunities occur for consolidation, that those are actually taken on board. So, ladies and gentlemen, thank you very much. I think we have about reached the point of no return. So remember when I started, I said that we had some things that we hoped we would have been able to deliver as part of the program. That's really for yourselves to be able to determine. I hope you have agreed that that the learning outcomes that we set out at the beginning have been delivered. At this point, I would say thank you very much. So I'm going to switch off my my sharing and come back to the screen, because we're now going to move into the point at which we could have our sort of question and answers. So, does anyone have any questions that they want to ask either Peter or myself? I say, other than what are the winning lottery ticket numbers? Because I don't know. If I did, I wouldn't share it with you. So any questions that we've got? So we said to beginning is, I know we were looking to have a gap and then come back for a 2-hour session of question and answers, but knowing that you are clearly very busy individuals, this is your opportunity to ask questions. So does anyone have any questions that they want to ask us at this point in time?
Just a question, Rob Tebelio again.
Yes.
Have you been in a situation where when one of the tenders or one of the bidders on purpose underbids a project, and he is awarded with the bid, and then he raises the price even, I don't know, I'm just, it's just an example, double the price that he bid originally? What happens in that case? I mean, do you have any experience? I see that Peter is laughing a little bit, so maybe he has had the experience. So, what happens in these cases? Is he disqualified? I mean, because the problem is that when that happens, maybe part of the project or the construction or whatever, talking about construction
Sure.
Projects, because sometimes they're very deep inside the contract and they're working, and maybe it's deadlines, could be even an emergency. So they're kind of really stuck into that. And then the procurement entity has no more, can't do anything about it. Just keep on moving and because disqualifying it at this time could be a really big mistake, let's say.
Yeah, I have. Thank you for the question. I have experienced where this has been the case, where someone's actually coming, and part of the process that we would follow is where the cost that's put in by a bidder, we believe is either abnormally low or is significantly lower than everybody else. Is we would be sure to check that they are capable of delivering it against that costing. And again, so the classic thing is often I see, and as a procurement, I don't particularly like it, is I've seen on bids E&OE, which is a sort of classic thing. So, well, we're putting this bid in, but things may change, things may adjust, or we put caveats in there as a means of being able to recover additional funds from there. Then I would say is you have to certify to me that you can deliver it against this cost, because if you deliver it against this cost, then we're okay. If you now can't turn around and deliver it against this cost, then effectively you're in breach, you're in default, and if you're in default, that then gives me the opportunity to go elsewhere to get someone else to deliver this program. And if it costs me more, then effectively it costs you more because you're in breach of contract. Because you're in breach of contract, then I can recover the costs from you for any additional costs I incur as a result of you being in breach of contract. And that's the sort of standard approach that I would take in terms of being able to do it. And I would say to people is, understand the consequences of what you've done. If you believe that you can deliver it against these costs, then fine, I will hold you to that because contractually that will be your obligation. Don't come back to me and say, sorry, I need to adjust it by whatever it is. Unless it's unforeseeable, then I'm sorry. If the fact you didn't foresee it is not my problem, that's your problem.
Correct.
I think
does that answer your question?
Well, yes. Yes, I mean, yes.
I think that's absolutely right. Ultimately, it's a breach of contract, and therefore it's a risk on the part of the bidder. If that's what they're going to try to do, then it is a huge risk because variations are not often permitted, and sometimes you have to have approval. And if that's not going to happen, then it's exactly what Rob says. You're in breach of contract, and you pay for the replacement if that's a requirement. But the one thing I would add is that I do see this, and I've seen this very often. But it's very rarely a risk that's being taken by the supplier on his own. It's usually part of a corrupt practice because what will happen is that the bidder will agree with the procuring entity or the person responsible for payment within the procuring entity that that's what's going to happen, that his bid will be accepted at below the price that it should be, and that there will be amendments and variations later. So that's, I think the reality, that's what happens most often. And clearly, there is a risk because if you're caught out, that's a much more serious risk than just paying the difference. That's actually criminal and could lead to imprisonment and fines and all the rest of it. But that's the context I see it more. And Rob's right. I mean, otherwise, if they're underbidding, then you would normally think, well, this is quite a
identified. Yeah.
So I think that's the way I would. One thing I would say as well, and I don't think it's an issue in BVI, but it's an issue I see in other places, and that is where governments rely on estimated prices as the ceiling price. So they will say, this is what our price, this is what we think we're going to pay, and this is the ceiling price. And then anybody who bids below or above is not going to get the contract because we know what the price is. That causes a similar problem, not quite the same, but a very similar problem because all the bidders, they will find out what that ceiling price is, whether it's advertised or whether somebody has got it, which itself is going to be corrupt because there'll be leakage. But that's not my problem. My problem is that bidders will bid against that price. So if they say, we think the ceiling price for this is 100,000, then you'll have all the bidders coming in at 99, 999 or 998 just to make it look as if there's competition.
Yes.
But because they're bidding against that price, they haven't taken into account the reality. So it will either be too much or too little, because the estimated price is only an estimate. So either if it's too much, then of course the bidder is going to be really happy because they're making a windfall profit, which is not good for the government, or it's too low, and then nobody can come in on time, on schedule, and then you'll have all of those problems, consequential problems. But that's the result of that's a self-inflicted wound. That's the procuring entity using a ceiling price against which the bidders will bid. So I know it's not the same, but I think you have similar consequences, and there are similar results for that. So I just thought I'd raise that as an interesting comparison.
Appreciate that.
If I could just clarify, please. Just to confirm, what you're saying is that while there may be negative consequences for the procuring entity or the people of the BVI, there's nothing in this legal framework that actually prevents that significant underbidding and then doubling the bid price by the time the contract's signed, so long as it's approved by the minister.
Well, if it's a significantly lower price, then it would be, you have to determine whether it's abnormally low or not. If it's not deemed to be abnormally low, then following investigation and assessment, then they would be held to that, which would not, unless there were variations that were allowed within the framework of the agreement, they would not be able to vary the cost and increase it in that way. So it would be, that's the price you quoted, that's how it would be within the law. And remember, you could use the issue that you've got as part of the single source as a principle, which says if it goes beyond a certain point, then there's something wrong and you need to revisit and reinvite attenders as part of that sort of process. So the principle is there in the Act. But yes, that's the approach that I would take in terms of abnormally low and hold them to it.
But you have to remember that this Procurement Act deals with everything up to the award of a contract. It isn't a contract law. But under contract law in BVI, if you fail to meet your obligations, i.e. provide at the price you say and on time, then you're in breach of contract. So the consequences would, you are prevented by contract law from breaching your contract. So that maybe not under the Procurement Act, but we don't need to put it in the Procurement Act because it's part of contract law.
Yeah.
So the Procurement Act deals with everything up to contract award, but not afterwards. So I think it may be too easy to say, well, the Procurement Act doesn't stop, but contract law stops. You can't do that unless there are variation clauses. And then I come back to, well, it's not only the contract law, it might be any criminal law that stops you being corrupt if it's part of the corrupt practice. So I think the law in BVI is strong enough to stop this happening one way or the other.
Okay, well, I don't know about Tebelio's question, but my follow-up question was focused not so much on after the contract has been awarded, but during the confidential part of the bidding process where prices have been submitted and the procurement entity says, right, well, these guys were the cheapest bid. And then you reach the point where the contract award is made public and the sum of the contract is made public and the sum of the contract is larger than your bid was.
Oh.
And so you go, well, you guys said they were the cheapest bid, but they've bid higher than us. So obviously they weren't. At that point, would we be able to then request an investigation?
I think probably yes, but it also depends on what the contract award, what the contract evaluation was. So if it was based on lowest price, then you clearly have grounds for making a complaint immediately. If it's the lowest price and the person to whom it was awarded is not the lowest price, you have grounds. On the other hand, if it was most advantageous tender, which is not only a question of price, you might still have grounds for complaint, but it wouldn't be just on the basis of price. It would be on how the evaluation was conducted and what those criteria were and how you fared on those criteria. So, the answer depends on yes, absolutely, or maybe, depending on what the award criteria chosen are.
But you would have the ability to be able to question the basis upon which your bid, based on the known evaluation criteria there in the bid document, where your bid was deemed to be deficient in comparison to the one which is proposed to be awarded.
Okay, thanks. I
Okay,
actually have a
clear.
completely separate question, if nobody else minds me just piggybacking on that one. Do we know if this law is going to apply to strictly the ministries or all government entities, such as, say, the Ports Authority or the RDA?
That's an interesting one, but that is covered. The state-owned enterprises, so government entities that are not strictly ministries, they have an option. They are allowed to establish their own rules of procurement, but they have to be submitted to the Central Tenders Board, and they have to decide whether or not they are compliant with the spirit of the Act. So, you know, they have to comply more or less with the Act, although they're allowed obviously some flexibility. Sometimes the sectors require some flexibility because of the types of product or the types of service being offered. And if the Central Tenders Board is not satisfied that the rules are compatible with the Act, then the Act applies in full. So it's a sort of carrot and stick. They're given a carrot. You can be a little bit more flexible, provided you follow generally what the rules say. But if you fail to do that, the stick is you follow the Act the same as everybody else. But that's a process. There's a time limit for that to happen, and that's built into the regulations, which are going to be adopted very shortly.
But if you think in terms of the broad rules that would apply, so is what they're doing transparent? Is it fair? And does everyone have the same opportunity? Then those are the broad principles. How that might be applied may be different given the nature of the particular markets that they actually operate in. But that's always, when in doubt, go back to the spirit of what the Act is actually saying, and saying is there anything which is likely to be in contravention to those broad principles? If it is, that's where you can challenge. But the state-owned entities have to follow the same principles. And as Peter said, is because of the nature of the marketplace and it's how we would, here in the UK, the utilities had a slightly different set of rules to the normal government departments, simply because of the way in which they operated, and they needed to have some greater flexibility in terms of being able to use negotiation and things like that. But the spirit of the thing was there, and they had to be able to justify where they did something different, that it still sat within the spirit of the legislation. I think that's what the Central Tender Board will do as part of their review, to make sure that they operate within that. If they do, fine. If they don't, then, as Peter said, is you'll follow these rules with no exceptions. So it's in their interests to make sure they hit the principles.
Okay, thank you.
Anyone else? Okay, well, if no one has any more questions, then I say I'm not in the business of keeping you here for 2 hours on the basis that that's what we said we'd do. You have the opportunity in terms of being able to sort of follow through with BVI officials. And I know I have an obligation. I will follow that through and send that through with BVI and let you have that in terms of the evaluation. If there is nothing else, I'd just like to say thank you for your attendance, your contributions. I hope you found it useful and is beneficial, and I wish you every success in any future procurements under the new regulations. Thank you very much, everybody. Do you have anything to say, Peter?
No, I just wanted to thank everybody for their attention. I know it's a long day going through procurement, so thank you for hanging on in there.
Thank you. Just a question, Rob. Are we receiving an electronic copy of the training sessions to be able to review and digest a little bit the content? I mean, or not? I mean,
I've got will not be in my gift, but I've put forward that request that you've actually made, and I would hope that would be the case. But I say I can't speak for for BVI government at this point in
No
time.
problem.
But I will,
No
but I will strongly encourage that they will actually do that.
Thank you. Thank you very much. Thank both of you. Bye.
You're welcome. Okay, thanks very much, folks. Take care.
Bye-bye.
Enjoy the rest of your day.
Bye-bye.
You too.
Bye.
Bye.
Bye.